Okay, ladies and gentlemen, we're not ready to begin yet, but I have a couple of housekeeping announcements that we need to make. I'm going to make, some of y'all are going to be mad, and some of y'all are going to have the chance to be very noble and honorable. And so what that means is we have a limit on how many people can be in this room. And it's not my limit, it's the fire marshal's limit. And the fire marshal has the right to shut this meeting down and make it stop. So what we have done is we have created an opportunity for an overflow room so that everybody who's interested can watch, and it's just across the street, easy to get to. So what my plan is, there are people who are here that are interested in a public issue, but there are also people here that are respondents to actions. And so it's their life, liberty, and property that's being decided today. And so I would like for us as a group to give priority to those who are respondents, to have chairs in this room, please. So if you're not a respondent, I'm going to ask you to be noble and honorable and help us out here. And if you can go to the overflow room and excuse yourself, that would be very much appreciated. Okay? And then what can happen? What'll happen is public comment will happen, things will happen, and people will come and go. So once chairs open up, you're free to come and join us. Okay? So does that sound reasonable? So if you're a respondent and you don't have a chair, if you're a respondent or a respondent's lawyer and you don't have a chair, please raise your hand. Okay, so we need to make room for these people. Okay? Please. Hello. Okay, seeing no volunteers. One volunteer. Thank you, sir. You're awesome. I appreciate it. The airlines normally give you a free voucher ticket to give up your seat, but we don't have those. So we'll just see how this goes. We'll just see how this goes. We'll just see how it goes. Okay, so we now have a quorum. We didn't have a quorum, so we're going to let Dr. Johnston have some time to get settled in before we begin. Be careful. Okay, I'm turning on the mics, so y'all will all have hot mics. Be aware. Be aware everybody has a hot mic now. We ask that you speak into the mics so that they'll be nice and clear. Well, that didn't work. Let's see. Let's try this again. Maybe that's too close. try to get. Okay. I think I can turn that first one off. I think I can turn this one off. Okay. Going to test yours. Okay. Very good.
Good.
Okay. So I'm going to call this meeting to order. It now appears that we have a quorum. I'm Matt Mashburn, the acting chair of the board. We have Sarah Gazelle to my right, who is present, and we have Dr. Johnston to my left, who is also present, and we're expecting Edward Lindsay, but he has not arrived at this time. So at this time, we will begin with an invocation. So I ask you to be respectful for the invocation, please, and we'll pray. Heavenly Father, righteous and glorious is your name, O Lord. You are a God of power and might. The heavens and earth are filled with your glory. Hosanna to you in the highest. We are grateful that we can be confident in what your Apostle Paul wrote in his letter to the Romans. For I am convinced that neither death nor life, neither angels nor demons, neither the present nor the future, nor any powers, neither height nor depth, nor anything else in all creation will be able to separate us from the love of God that is in Christ Jesus our Lord. Indeed, the only thing that can separate us from your wondrous love freely given is the contents of our own hearts. Search our hearts, O Lord. Where you find enmity and strife, replace it with love and joy and peace. Where you find rivalries and dissension, set in place forbearance and kindness. Where you find factions and fits of anger, set in place goodness, faithfulness, gentleness, and self-control. Banish from our presence all forms of spiritual wickedness, O Lord. Bless our election workers and our county officials, O Lord. Have your angels throw a ring of protective fire around those who work so diligently and faithfully on behalf of their fellow citizens. Let them constantly feel your presence nearby. Stay close to all those who enable their fellow citizens to continue our republic, O Lord, the longest running and most successful experiment in self-government of, by, and for the people. Help us to love you, O Lord, and to love our neighbors. Bless our neighbors near and far. Bless the citizens of Georgia, from Brasstown Ball to Tybie's Lighthouse, from Hiawassee and Blue Ridge to Albany and Americus, from Lafayette, Somerville, Ringgold to Adele and Sparks, from Columbus to Augusta. Bless the state of Georgia, O Lord, and all its inhabitants, from the north to the south, from the east to the west, and all points in between. For thine is the kingdom and the power and the glory forever. Amen. We'll next have the Pledge of Allegiance, so please stand and face the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Please be seated. Okay, we're going to do a couple of housekeeping items, and then I'll turn it over to Sarah for a special presentation that she has, but just a couple of items that we would normally handle if the board had a website that we've asked for. If we would get it, we would be able to post things such as this, but we'll do it now. First of all, some of you who are regulars to the meeting might notice that there's not a court reporter present in the room with us. The reason for that is the court reporter is sick, and the court reporter's family is sick. So it is something that is very contagious, and so therefore I asked that rather than us become a super spreader event, that the court reporter will report this remotely from the live stream. So if you see that there's not a court reporter, don't be alarmed. There is a court reporter. Just in the interest of safety and health, we've asked the court reporter to do it remotely. The second question that I get frequently is, does the chair participate in the meeting? Does the chair get to vote? And we have not adopted Robert's Rules of Order as a firm procedure, but we follow Robert's Rules of Order as a guidance. And from the official Robert's Rules of Order webpage, you can look it up if you wish. It's robertsrules.com. But in a small board, the chair is when the chair is a member of the board, the chair has all the powers of any member of the board. The chair can make motions, the chair can vote, the chair can participate. What has been the tradition in this board is that so as not to unduly influence the discussion and to let the other members be free to discuss, the board usually defers to the end and usually either might not vote or might not comment until the very end. But to answer the question, according to Robert's Rules of Orders, on a small board, the chair participates, the chair votes. A lot of you might be familiar with the rules of the Senate. And in the Senate, the United States Senate, the vice president is the presiding officer, but is not a member of the Senate. The vice president is not a senator. So the vice president only votes in the event of a tie. Now, Robert's Rules, that's a special Senate rule, and Robert's Rules has a different rule in that even in a large body where the chair does not participate, the chair can either make a tie or break a tie, either one. But we're a small board, and so the chair is a member, and so the chair participates fully in all aspects of the board. Let's see if there was anything else on that. No. The next thing is we've had a frequent question about continuances, and for those who don't follow the board or not familiar with the board's processes, the board members receive reports on the cases prior to the meeting so that the board members can study in great detail, and the board members put a lot of work into these cases, and sometimes they'll have questions about issues that they would like to have answered. Now, you can do that one of two ways. You can have the case presented, the board member asks their questions, the presenter go back and find the answer and come back a second time, and you end up hearing the case twice. So to make efficiency the primary goal, the board members ask their questions, and sometimes the questions can be answered in advance of the meeting and sometimes they can't. And so if a question has been asked that can't be answered in time for the meeting, the matter is continued and so that the answer can be found and reported back as part of the presentation of the case. We will also grant continuances very freely and quite often if an attorney has been retained at the very last minute. It's unfair for that attorney to be required to present a case that they're not familiar with, and so we will frequently grant continuances of that nature. So you will see both types of continuances today. For the board, it is a relatively common and routine event, but if this is your first time attending a board meeting, it might strike you as odd or weird, but just go ahead and answer that question. The next is to remind you once again, if you don't have a seat, we have in the Coverdale Legislative Office Building, which is immediately across the street, room 606, we've made available for overflow seating. And the good news is it is a lot warmer than this room. So if you're freezing in this room, I offer you relief instead of a free ticket on our next flight, like the airlines might be able to do. So Coverdale Legislative Office Building 606 is an overflow that we've made available for you. So with that, I'm going to turn the program over to Sarah Gazelle for a special presentation.
Thank you, Mr. Chairman. I just wanted to take the opportunity to acknowledge the tremendous loss that Georgia suffered about a month and a half ago with the passing of Stephen Day. Stephen Day was a husband, a father, a very proud Georgia Tech graduate and engineer, but he was also a long-standing board member in Gwinnett County's Board of Elections. Stephen was the Democratic appointee to the board for more than 10 years. And in that time, he dedicated hundreds and hundreds of hours to make sure that the citizens of Gwinnett had an opportunity to cast their ballot and that that ballot would be counted. He spent his time looking at engineering schematics, going to MIT, trying to make sure that everything was done in the best and most efficient way. When I called Stephen a couple of years ago to ask if he would be willing to participate on the county review board for Fulton County, he was reluctant to do it because he wasn't sure whether or not it would be addressed in a way that it should be. And he agreed to participate in that exercise under the condition that he was allowed to operate with no undue influence, that the panel would operate in good faith, and that the goal of it was to improve the processes for the people and the voters of Georgia. And that is how he addressed and faced everything. Stephen received a diagnosis of pancreatic cancer and passed 3 weeks later. He was a good friend, and he was a good and faithful servant. And Georgia is poorer for his loss. My heart and my prayers go out to his family and to the state for his loss. And I want to acknowledge the contributions that he made to all of us in this room and across the state of Georgia. Thank you.
Thank you very much. Thank you very much, Sarah, for that presentation, and we do appreciate the service that was provided by this dedicated person, in that he spent just untold hours on the review of Fulton County, and all the citizens of Fulton County who vote have been the beneficiary of his hard work and the improvements that were made as a result of it. So we appreciate that. The next item on the agenda will be the approval of the board meeting minutes. Has the board had the opportunity to review the minutes?
Yes.
Are there any adjustments or changes to the minutes?
I have a change, Mr. Chairman.
Okay. Looks like you're toward the end on
Toward
the
the
last
end,
page.
under procedure matters,
Okay.
the LNA petition vote reads, the board voted to reject all of the aforementioned. I would like to record my vote in favor of the logic and accuracy testing petition.
Okay, a motion has been made to amend the minutes to reflect Dr. Johnston's affirmative vote for logic and accuracy testing petition. Is there a second?
Second.
Any discussion? All those in favor of amending the minutes to record Dr. Johnston's affirmative vote for logic and accuracy testing would say aye.
Aye.
All those opposed would say no. Okay. With that amendment, are there any other amendments or adjustments to the minutes?
I move that we accept the minutes as amended.
There's been a motion to accept the minutes as amended. Is there a second?
Second.
Is there a discussion? I doubt that there will be a discussion, so hearing no discussion, all those in favor would say aye, all those opposed would say no.
Aye.
Aye. So the minutes are adopted. The next item on the agenda will be the Attorney General's report, and this is normally something that we take up at the end of the meeting, but the Attorney General is busy with numerous lawsuits that they need to prepare for, so we need to get their report heard and let them be on their way. So if I ask Russ to come up for the Attorney General, please. And I've turned on your mic, so you should be ready to go.
Reverb a second to.
It might be me, so let's try and see if I use this one, if that works better. Okay, the floor is yours. For the Attorney General.
The first case on the Attorney General's report is out of DeKalb County. It is a proposed resolution to 7 State Election Board cases, 2015-85, 2016-42, 2018-39, 2020-45, 2020-160, 2020-175, and 2020-215. These cases involve DeKalb County's configuration of a ballot and the handling of absentee ballots from the 2014 election. It involves failing to provide adequate training regarding the setup and operation of express polls for the 2016 election. It involves the failure to place eligible voters in the correct House district. It involves the failure to issue absentee ballots upon proper request for the 2020 primary election. It involves delayed openings in 2020. And it involves the processing and handling of absentee ballots during the 2020 election cycle. The proposed resolution of that case is the imposition of a $7,000 civil penalty, a cease and desist, a public reprimand, and a requirement to provide documentation of the DeKalb County Board's updated process for handling and storage of absentee ballots and additional training. Second case on the Attorney General's report is Chatham County 2020-62.
Hang on just a second. Is the board's desire that we handle these one at a time, or just let the Attorney General present them all and we'll take them as bulk?
Maybe one at a time.
One at a time?
All right.
Okay. One at a time? Okay. So without objection, so ordered. Is there a motion to accept the consent order or finalize the consent order in DeKalb County 2015085, 2016042, 2018039, 2020-045, 2020-160, 2020-175, and 2020-215.
So moved.
Okay, there's been a motion, and I'd like the record to reflect that we've been joined by Board Member Edward Lindsay, so welcome to you. Your mic is on, and I'll give you a second to settle in. So there's been a motion to adopt or finalize or approve this consent order. Is there a second?
A second.
Okay, there's been a motion and a second. Is there any discussion? Hearing. Okay, Dr. Johnston has a question.
Mr. Chairman, a question, if there's a DeKalb County election official here represented?
Seeing none.
Yes.
Right there.
Oh, wait,
Ms.
seeing one. Still don't see him. Okay, there we go, okay.
Might I ask confirmation that the deceased registrants in the DeKalb County voters list, were they removed?
I see a nodding in the affirmative
Sir?
while she moves closer to a microphone. Let's see if we can get you a mic. If you'll, right in front of you, you'll see a panel that has a button that says either speak or talk. Right in front of you, you'll see a panel that says speak or talk. Okay, I see you. You're now live. Please introduce yourself for those who don't know you. We know you, but please, for those who don't know you, please introduce yourself.
Good morning. I'm Keisha Smith. I am the Executive Director for DeKalb County Voter Registration and Elections.
Thank you. Okay, Dr. Johnston asked if the decedents had been removed from the rolls, and I saw you nod in the affirmative if you'd like to expand on that answer.
Yes, it is my understanding that those measures had taken place. And so,
Thank you.
yes.
Further discussion? We're prepared to vote. All those, there's been motioned and seconded. All those in favor would say aye.
Aye.
All those opposed would say no. Passes unanimously. Thank you, Mr. Attorney General's office. Russ, if you'd proceed to the next case, please.
Thank you, Mr. Chairman. The next case is Chatham County 2020-62. This involves the June 2020 general primary election. There are a number of violations against the Chatham County Board of Elections. The board had an incorrectly placed Board of Education race on the ballot that was submitted to the election center. They failed to properly notify the Secretary of State in advance of the early processing of absentee ballots during the primary election. They had a late opening precinct. Election workers violated the prohibition on cell phone usage during the early days of the pandemic in terms of they retained their cell phones during election administration because of medical issues with family members during the early days of the pandemic. They changed certain polling locations due to the requirements of the pandemic. They maintain that they sent workers to post notices at all the old locations, but some of the old locations did not have the notices physically posted at them. And there was a failure to maintain records of certain clerks' oaths. This resolution calls for a consent order with a $400 civil penalty against the Chatham County Board of Elections. In addition, there is an individual respondent who is a member of the Chatham County Board of Elections. And during that general primary election, he did a Facebook Live video to his personal Facebook page during the absentee ballot processing. And the proposed consent order for him calls for a $100 civil penalty, a cease and desist, and a public reprimand. Those are the two consent orders for 2020-62.
Questions by the board? Questions by the board? Hearing no questions, I'll entertain a motion to adopt this consent order.
I move that we adopt the consent order.
There's been a motion. Is there a second?
Second.
There's been a second. Any discussion? Hearing no discussion, we'll put it to the vote. All those in favor of approval? Hearing no discussion, we're ready for a vote. All those in favor would say aye.
Aye.
All those opposed would say no. Motion passes unanimously. We'll move to the next case.
Thank you, Mr. Chairman. This is Stevens County, and this consent order proposes to resolve 4 state election board cases: 2020-15, 2020-33, 2020-156, and 2021-56. These cases entail the local board's failure to provide notice of the physical location of the drop box on the county election website, and for not having the signage at that location designated by the Secretary of State. The board failed to maintain the documentation regarding the opening and the closing of polls. The board failed to maintain the documentation regarding the training provided to poll officials. The board failed to timely enter voter data during the 2020 election cycle. The board failed to provide absentee ballots to 2 Stevens County voters who had made timely and proper application. The board failed to register 3 Stevens County voters after submission of registration forms. The board failed to adequately secure a single absentee ballot in the election office. The board failed to maintain proper absentee ballot drop box logs and ballot recap sheets for the January 2021 runoff election. And they failed to respond to several timely open records requests related to the 2020 election cycle. Stevens County also, for 2021-56, self-reported 3 double voters for the general election runoff. The proposed resolution calls for a cease and desist, a public reprimand, a civil penalty of $3,000, $536.28 in assessed investigative cost, and additional training for Stevens County election officials.
Questions from the board?
If I may, Mr. Chairman, given what they didn't do, did they at least have a monitor of the drop boxes in place, a camera drop box, or do you know?
I believe the only issue regarding the drop boxes that the investigation sustained was that they failed to provide the physical location on their website and the signage by the Secretary of State. There were no additional violations regarding the drop box.
Just curious.
Further questions from the board? If no further, sorry.
Question, is there documented evidence that they will maintain election documents in the future?
That would be part of the cease and desist, right?
Yes, because that is a continuing obligation going forward. That's part of the cease and desist to commit no further violations of the election code or election regulations.
That's great.
Okay. Questions from the board? Okay. If there's no questions, we're ready to entertain a motion. Is there a motion?
So moved.
There's been a motion to adopt or accept this consent order. Discussion? All those in favor would say aye.
Aye.
All those opposed would say no. Motion passes unanimously. Thank you. If you move to the next one, please.
Thank you, Mr. Chairman. Next case is 2020-147, Paulding County. This resolves a complaint against the respondent, April King. She was a poll worker who allowed a voter to vote twice, once in an absentee election, and once via absentee ballot and once in person on the ballot marking devices. This resolution against this former poll worker calls for a cease and desist, a public reprimand, and imposes a civil penalty of $250.
Okay, questions from the board? Dr. Johnston, you ready?
Sorry, Mr. Chairman, no question, but I would like to make a comment for the record. that a majority of these consent orders involve problems with absentee voting and absentee ballots. So that at the earliest convenience, maybe in new business, a motion could be made for us to consider recommending to the General Assembly to no longer have no excuse absentee voting.
Okay, I don't know if anyone remembers our last meeting, but we adopted the theory of jazz hands rather than applause. So those that are familiar with our process, please demonstrate jazz hands. Thank you. So that's how we do it. So thank you very much. I appreciate it. Thank you. Okay. So let's see, no further questions or comments from the board, there'll be a motion to adopt. Okay, there's been a motion that we approve this consent order. Is there any discussion? Wait, I need a second. There's been a second and a motion and a second. Any discussion? Hearing no discussion, we're ready to vote. All those in favor would say aye. All those opposed would say no. Motion carries unanimously. Please proceed to the next case.
Thank you, Mr. Chairman. The next case is Long County 2020-36. It has multiple resolutions in the case. The first is a consent order against Hamilton Evans Jr. Mr. Hamilton, or Mr. Evans, requested an absentee ballot and then asked for a second ballot because, quote, he wanted to test the system. He was bound over to the district attorney's office for potential criminal prosecution, and the consent order here calls for a $1,000 civil penalty, a public reprimand, and a cease and desist. There is also a proposed final order against other double voters for that general primary election who voted twice, but did so because of confusion regarding the fact that they were issued absentee ballots earlier in the cycle. If you'll recall, 2020 was, you had the presidential preference primary scheduled in March. Absentee ballots had gone out for that. Then the election was postponed and held in conjunction with May, the May general primary, and then the May general primary was delayed until June. As part of that, these 5 individuals inadvertently voted 5 times, as opposed to Mr. Evans, who intentionally voted a second time.
And just to correct.
I'm sorry, 5 voters voted twice, not 5 times. That's on me.
I appreciate that clarification.
Yeah.
Any questions from the board?
Yeah, Mr. Chairman, if I may. You know, our jurisdiction is, and our scope is generally limited to civil penalties, and that's what you guys take up for us when we refer to the Attorney General. If there's a criminal conduct that we believe has taken place, it goes to the DA, and the DA handles it. Given the fact that someone was intentionally voting twice, not out of confusion, but intentionally voting twice, you mentioned that that was referred to the DA. What, if anything, has happened with that?
Our office has no involvement in that.
I know, I'm just whether or not you knew or not.
I do not have knowledge as to what the DA's office may have done with it.
I'm sorry, it says so in the book that
Actually-
that it was declined. I'm sorry, I missed that in the journal. I think maybe we need to sort of push on that a little bit harder when it comes to someone who intentionally violates our laws and votes twice for whatever reason, as opposed to someone who simply gets confused.
I understand. I will state from personal experience that may be an issue for the General Assembly because election criminal violations, I think, in many prosecutors' offices are considered lower priority issues.
Yeah, understand. Thank you.
Mr. Chairman,
Dr. Johnston's recognized.
I'd like to point out that the violation for double voting does not include intent. The violation for the of statute 572 merely says double voting is a felony. It's our job to investigate and report, and it's up to the DA or the Attorney General to decide the circumstances of the case. So, unless and until we enforce the statutes, rather than just considering them suggestions of how we should conduct elections, I think we are not doing our proper job.
Come on now, help me out here. All right, let's see. Further comments or questions from the board? Hearing none, we'll entertain a motion to accept the final order in case number 2020-036. Is there a motion?
Actually, Mr. Chairman,
Sorry.
remember there is a consent order as well as a final order.
Thank you for that clarification. So is there a motion to accept the consent order and the final order in case number 2020-36? Thank you for that clarification. Is there a motion?
So moved.
Is there a second?
Second?
There's been a motion and a second. Is there a discussion? Hearing no discussion, we're ready to vote. All those in favor would say aye.
Aye.
All those opposed would say no. Carries unanimously. Okay, if we can move to the next case, please.
Thank you, Mr. Chairman. This is a final order proposing to resolve 2020-69 Pickens County. This involves a poll watcher who attempted to move from the designated area for poll watchers to a vantage point closer to the registration table. When asked to return to the designated area, she engaged in a verbal altercation between the poll manager and herself, and the Sheriff's Department was called to the polling location. This final order proposes to resolve the matter with a cease and desist and a public reprimand.
Comments, questions from the board? Hearing no comments or questions, we're ready to entertain a motion to approve and execute this final order. Is there such a motion?
So moved.
There's been a motion to approve and execute the final order in case number 2020-269. All those in favor, is there
A second?
a second? Thank you. Is there any discussion? Hearing no discussion, we're ready to vote. All those in favor would say aye.
Aye.
All those opposed would say no. Passes unanimously. We're ready to continue to the next case, please.
The final item on the Attorney General's report concerns Respondent Sherdon Rusum Reynolds, SEB case number 2021-328. It involves a finding that this individual engaged in photography at the polls, and the proposed final order incorporates a cease and desist and a public reprimand so that this individual does not engage in photography at the polls going forward in violation of the election code.
Is there any questions or comments from the board? Hearing no questions or comments, the board is ready for a motion to adopt this consent order, or final order, consent order, final order? Help me.
Final order.
Final order. Although, is there a motion?
So moved.
It's been a motion to adopt the final order and execute it. Is there a second?
Second.
Okay, there's been a motion and a second. Any discussion? Hearing no discussion. Oh,
Brief discussion.
okay.
As far as photography, I totally agree that there should be no photography while voting is taking place. But I would like to make the point, once the election is over and the polls have closed, that photography in areas that don't involve personal identifying information or photography of private information like passwords, that photography, in my opinion, is okay with regards to, photographing tabulation or processes that are going on in the election area. It should all be public, so why not allow photography?
George Balbona had jazz hands on that one.
I saw that, George.
I think I saw. Yeah. Okay, so if there's no further discussion, we are ready to take we are ready to vote. All those in favor would say aye. All those opposed would say no. Okay, motion passes unanimously.
That concludes the Attorney General's report, Mr. Chairman.
That concludes the Attorney General's report, and we thank you very much for your service and the excellent presentations and the hard work that's gone into resolving these issues on behalf of the board. We literally couldn't do this without you, so thank you very much. We appreciate your hard work.
Thank you, Mr. Chairman, and I will, even though you have been dismissed as a defendant, I will apprise the board of how tomorrow's hearing goes in front of Judge Jones.
Well, thank you on both counts for having us dismissed and keeping us informed. Thank you very much.
Special thank you.
Now, one of the things that the board does very frequently, if you're not a avid watcher of the board's meetings, you probably don't know about this, but one of the things we do is frequently you'll take cases out of order in order to accommodate requirements of lawyers who have to be in courtrooms throughout the state. So we do that as an accommodation to judges that are working hard for the public and to keep their calendars on schedule, and to not increase the burden on respondents that they have to pay additional attorney's fees in addition to whatever there might be a penalty or a fine that's imposed, so that we don't increase that. So one of the cases that the board has asked and has been granted by unanimous consent to be taken out of order is case number 2020-263 Monroe County. 2020-263 Monroe County case. And Mr. Owens is here, Sarah's here, I forgot, is here. Normally, we would let y'all present from your desk. If you're at a desk, you have a microphone, so I'll turn on your microphone at the appropriate time. And if somebody who has a desk would make available for our counselor here to be able to speak, that'd be a big favor to the board, and we'd appreciate it. Okay, so this matter is for the board's purposes, tab number 40. Tab number 40. Tab number 40.
I have a handicap notebook here.
Tab, now I'll give you a second, give you a few minutes to get there. Mr. Cross has offered up a microphone. Thank you, Mr. Cross. Appreciate that. On the brass panel in front of you, you'll see a little button that says speak or talk or something. So at the appropriate time, if you just press that button. Yeah, he's going to use one next. Okay. There you go. Okay, so as the Secretary of State's office is ready to present, we are ready to hear. The floor is the Secretary of State's.
Case number 2020-263, Monroe County nomination petition. On December 16, 2020, the investigator received a complaint alleging various procedural violations during the circulation of a nomination petition for independent Monroe County Commissioner candidate LaMarcus Davis. These allegations consisted of LaMarcus Davis falsely declared he was a sole circulator of 15-page nomination petition. LaMarcus failed to certify each page of the nomination petition with a circular affidavit, the forged signatures on nomination petition, duplicate signatures on the petition, forged and duplicate signatures. There were 3 citizens, Prentice Shannon, Bree Shannon, and Wanda Shannon, who denied having signed the nomination petition. It was strongly suspected that a family member named Kimberly Shannon signed their names. Although she denied that she actually signed the names, her signature closely resembled the signatures appearing on page 4, lines 2, 3, and 4 of the petition. Candidate LaMarcus Davis falsely swore that he was a sole circulator of the nomination petition. He completed 1 circulator affidavit for all names to be considered for the name to appear on the ballot as an independent candidate for Monroe County Commissioner. The investigation revealed that Davis and his mother, Barbara Davis, and others obtained names for the petition. Ms. Furlow accidentally signed in 2 places on the nomination petition. That was page 5, lines 5 and 6. Kay Warren and the Elections and Registration Office qualified candidate LaMarcus Davis using a nomination petition with errors and defects. It was stated that this was a training issue and more training was requested so this error would not happen again. Ms. Taylor Biddick signed her husband's name, Lawson Biddick, on a nomination petition with his express consent and permission. The potential violations found were that Monroe County Board of Elections and Registration, Kay Warren, violated OCGA 21-171, the examination of a nomination petition. LaMarcus Davis and Barbara Davis violated OCGA 21-170, subsection D, by failing to complete circulatory affidavit for each page of the obtained signatures. Lakeisha Furlow violated OCGA 21-170, subsection C, nomination of candidates by petition, by signing the nomination more than once. Kimberly Shannon and Taylor Biddick, respectively, violated OCGA 21-170, subsection D, subsection 2, by manually signing a name on the petition other than their own.
Does that
That's it.
complete your presentation? Any questions by the board for the Secretary of State's investigators? Okay, hearing none. Mr. Attorney, we have the honor of having a former Attorney General with us today, Sam Olens. So by virtue of your public service, you get to go first among your other attorneys. So please, we'll hear what you have to say.
Thank you, Mr. Acting Chair.
You should be on now.
Okay, thank you. Thank you very much. It's a pleasure to be in front of you today. I have the pleasure to represent Kay Warren, the election supervisor.
Hang on, that's me. Okay.
Her one colleague is also here today. It's a 2-person office, small rural county. The county chair, Greg Tapley, is also here today to show his seriousness about this matter, as well as his support, frankly, of the election supervisor. And of course, Ben Vaughn is here. He is the county attorney. So if I mess anything up, he'll tell me and you.
Okay.
So in essence,
I've got a little bit of a technical dilemma here in that if I try to turn your volume up, I'm going to get the feedback. So I'm going to need you
Okay.
to hold it closer. Yes, sir.
I'll make
Thank
believe.
Thank you very much.
Thank you. So in essence, as it relates to the registrar for elections, it states she accepted a petition with forged and duplicate signatures. Now, I would suggest to you, sir and ma'am, there's no way a registrar has any training to know a forged signature. She has no background on signatures. She has no ability to do that. With regard to duplicate signatures, Ms. Warren went through page by page. The candidate needed 136 signatures to qualify. He submitted 15 pages with 210 signatures. After going through each page, he still had more than 136 signatures. So she did, in fact, look at duplicate signatures and, in fact, disregarded them, which is exactly what's required by 21-2-171A3. That's the express meaning of that subsection. She did talk to him when he first told her that he wanted to run as an independent candidate. He did give her a package with materials. But Ms. Warren also called all of her neighboring community registrars. Not one had ever dealt with an independent candidate before. And once again, let me mention, we're not talking about Cobb, DeKalb, Fulton, Gwinnett. We're asking an awful lot of a small rural county registrar's office. She then called the individual that she generally would ask questions to in Macon. Now keep in mind, this is during the heat of COVID. No return calls. Several attempts, no return calls. I am not for a second criticizing the Secretary of State's office. I think they had more on their plate at that point in COVID than any office should ever have. As you recall, the elections were, the dates were changed, the number of signatures were lessened. Clearly, the Secretary of State's office was under an awful lot of pressure and stress at that time. Now, if you look at 21-2-170D, it does use the word sheet. So technically, the only mistake Ms. Warren made was she did not require a separate certification sheet per page. There was one certification page signed by the independent candidate. But if you go on the Secretary of State's website and if you look up the nominating petition for independent campaigns, at the bottom of each page it says page number, and then there's a blank line where you put 1, 2, 3, 4. But when you print the petition, it's 2 pages. One page is the nominating petition, the next page is the certification. If you follow the statute, the signature for certification is either supposed to be at the bottom of the page or it's supposed to be on the back of the page. So when you print the page from the Secretary of State's website, that page is inconsistent with the statute. So we're now asking the Monroe County Registrar to do better than what the website regarding independent candidates does. Ms. Warren and her assistant were both in Athens last week for a 4-day training. The acting chair, in his infinite public service, attended that meeting in Athens. 0 minutes of that multi-day training was on independent candidates. Now let's be honest, how often does a county deal with an independent candidate? I'm sure there are a lot of other sections of Georgia's election law that take a lot more time. But once again, we're asking a small rural county to know every little indicia of Georgia law in this regard. When an investigator came to Ms. Warren's office and asked for copies of documents, she readily gave it to him, and he told her not to worry about it. And she didn't worry about it until she got a 1-page letter from the Secretary of State's, from the State Election Board, telling her that there would now be a hearing for today. Of note, that 1 page, it's not dated, it's not signed. So once again, we want the Registrar of Monroe County to act like a 20-year lawyer on election law. But I can't imagine any state agency is supposed to be sending out documents without a date and without a signature, but that's what we have. Now, we acknowledge that she made a clerical mistake. It should have been 15 certifications rather than 1. That's the only thing she did wrong. And I would suggest to you that the solution to that mistake is training. Not more and better training, but training, because frankly, she's never received training to date on independent candidates. So I think the result of this matter as it relates to Ms. Warren is that when all of the registrars next get together, noting next year is going to be a different election year, there's got to be specific training on independent candidates. And Ms. Warren and her assistant are readily available to come to either Macon or Atlanta any day in between then that the State Elections Board and the Secretary of State's office wants to get separate training on independent candidates. We all know that training helps you do a better job for the citizens of our state. And Ms. Warren and her office want to do an exemplary job for the citizens of Monroe County and the state of Georgia. So you'll now be hearing from other counsel with regard to other parts of the case. The only part that really relates to Ms. Warren is what I mentioned before, the certification and the fact there was 1 versus 15. And I would suggest to you that's not a matter that should be referred to the Attorney General's office. That's a matter where there should be a letter stating you've agreed to training on independent candidates. We're giving you training on independent candidates, but at the same time, I think this board should suggest that all registrars receive training on independent candidates. Thank you very much for your time. Yes, Mr. Chair.
Questions for Mr. Owens by the board? Any questions by the board for Mr. Owens? You are two. Dr. Johnson has the floor.
So, Mr. Owens, to your knowledge, or maybe somebody from the Secretary of State, is there a training video for independent candidate petitions?
I would defer to the office. If there is one, we'd love to view it. I mean, I'm not being sarcastic. We all agree training would be helpful. Training would be necessary. But Ms. Warren has been the registrar, I believe, since 2017. And in that time frame, she hasn't had training with regard to independent candidates.
Or even a procedural manual or some written instruction available?
She gave the candidate what was on the website, which includes the petition and certification that's inconsistent with the statute.
Thank you.
Thank you, Doctor.
Other questions by other members of the board? Member Gazelle?
I would move that we take this case apart and for each individual respondent and dispose of each individual respondent separately.
Okay, there's a unanimous consent motion on the floor to allow this case to be bifurcated or trifurcated and the individual respondents be treated individually. Is there any objection? Without objection, so ordered. So do you have questions or a motion?
I have a motion that we issue a letter of instruction to the county because it is clear in the statute that individual signatures for each page are necessary. But I do not see this as rising to a need for a referral to the Attorney General's office.
Okay, there's been a motion that this be handled by letter of instruction. Is there a second to that motion?
I would, a second.
There's been a second. Is there discussion?
If there is training available for independent candidates, I would ask that in the letter of instruction, there be a requirement to obtain training for such. And if there's not, then this would be a good suggestion to make to the Secretary of State's office. to provide this.
Okay, there's been a unanimous consent motion that the motion be amended to provide that a training either be obtained or be made available. Any objection to that unanimous consent motion?
I see that as a very friendly amendment.
Okay, the motion is now amended to provide for a letter of instruction and that the county should either obtain training or that training should be made available. Any further discussion? Hearing none, we're ready to vote on the motion to adopt a letter of instruction against Monroe County with a further instruction to obtain training, or that if training's not available, that it be made available. All those in favor would, oh, sorry.
Chairman, for the record, I have to recuse myself from this matter.
Okay.
From this particular individual.
Okay, since this part of the case has been trifurcated or bifurcated out, separated out, Board Member Lindsay has recused himself from this particular part of the aspect of the case, and that does not require a motion, and so that is granted. So now we restate the question. The question before the board is to issue a letter of instruction to Monroe County, and that Monroe County either obtain training on the issue or that it be made available to them. Any further discussion? Hearing no further discussion, we're ready to vote. All those in favor would say aye.
Aye.
All those opposed would say no. Okay, that part of the case has been concluded. Thank you, Attorney General Owens, and unless you'd like to stay for the remainder of this case, you are dismissed. Free to go. Okay, of our assembled esteemed counselors, who'd like to go next? Please identify yourself for the record.
Thanks, sir. I was here with Mr. Owens on the county's portion of the case. I think it's probably Mr. Welch is next, or either the gentleman
I
standing.
didn't even look in your direction. I'm so sorry. Were you up first? Did you stand first? We should take you, I didn't even look in your direction. I'm so sorry. Please identify yourself for the record and press the button and I'll turn your mic on. You're good to go. I'm sorry I didn't look in your direction. I was faced to my left. I apologize.
Not a problem. My name is Travis Hall. I'm the attorney for Mrs. Taylor Biddick and Mr. Lawson Biddick, named in the petition. Ms. Biddick is accused of putting her husband's name on the petition, which she did. She was at home, and her friend LaMarcus Davis came to the door, asked if she'd like to sign his petition, which she did. And she happened to have her husband on the phone at that time and asked him on the phone, do you want to put your name on this petition? He said yes, and so she wrote his name. She didn't sign it, she printed his name. She did not know that was a violation, and had no intent to deceive anyone, had Mr. Biddick's express consent to do so, and we believe that a letter of instruction would be appropriate. This is not a matter that I think needs to be referred to the Attorney General's office. Ms. Biddick did not disenfranchise anybody. Mr. Biddick is here. He was more than willing to state that he was on the phone at the time and asked her to put his name down. And I believe the investigator's report is accurate as to Mr. and Mrs. Biddick. And that's really all we have for the board.
Questions from the board? Board Member Lindsay is recognized, has the floor.
What does your client do for a living?
She's an attorney. I would point out to the board that Ms. Fiddick is a civil defense attorney. She is not an election law
I know.
expert. And in our profession, we routinely sign with express permission from others, particularly others in your firm. This was not something that seemed out of line or out of ordinary and normal course of practice. Pleadings are often signed by somebody else with express permission.
Mr. Lindsay still has the floor.
Yeah, I'm still trying to figure that out. You know, given the fact that it is a petition, and I do recognize that, you know, it is helpful that she had her husband on the line at the time, but I do think lawyers are held to a higher standard, and hope you understand that. I don't think her intent was to deceive, as shown by the fact that she asked her husband, but I do hold lawyers to a higher standard, and that's sort of a comment on my part, and that's what I'm struggling with here. If she was a layperson who had talked to her husband and then printed his name, I'd be a lot more understanding. But as an attorney, I must admit I'm struggling a bit with that. You can respond or you cannot. I'm just letting you know what I'm trying to figure out here.
Ms. Fiddick would like to respond.
Sure.
Good morning. It's true, I'm an attorney. I certainly was not thinking like one when my friend, Mr. Davis, he's a family friend of ours.
Yeah.
We knew he was trying to run for office. I believe it was a Friday evening. He came by. I was on the phone with my husband, said, "Hey, LaMarcus is here at the door." He said, "Yeah, you know, I'm trying to run for office. I'm just trying to collect, trying to get this petition signed, put my name down." My husband said, "Yeah, put me down." Certainly was not thinking about a lawyer, like a lawyer, or as thinking about election law. Certainly now I've been educated that what I did was wrong. I'm embarrassed. I'm apologetic. I apologize to the board. And I apologize to LaMarcus. It was certainly not my intent to cause any flaws in his nomination petition.
Understand. Thank you.
And Mr. Lindsay still has the floor. Okay. Mr. Lindsay yields the floor. You said that Mr. Biddick is here?
Yes, Mr. Fiddick's right here.
Mr. Biddick, I hate to put you on the spot against your will, but I know Dr. Johnston always likes to hear from the other person, so I'll go ahead and anticipate her question and let you have a time. Do you have the same microphone, or do you need another?
I have the same microphone.
Okay, very good.
Yes, ma'am. You have questions, or you don't?
Was the representation that you were on the phone, do you agree with that and
It was
all?
accurate, yes.
Give us kind of your side of the story on that issue,
Well,
if
I
you
was
would.
at work, and I was talking to my wife like any other time. She said somebody was knocking at the door. It was Mr. LaMarcus, wherever he went. And that was it. And she just simply asked, would I sign that petition? And I would. I would tomorrow.
And so had you been there at the house, you would have gladly signed it your own self in person?
Absolutely.
Okay.
Absolutely.
All right. Other members of the board like to ask questions? Thank you, Mr. Biddick. I appreciate it. I don't know if you were prepared to be on the spot, but I appreciate it.
At the appropriate time, Mr. Chairman.
Okay. Any other discussion, comments by the board? Mr. Lindsay has the floor for a motion.
Yeah. Two things that I was taught as a young lawyer. Lawyers should never make a mistake. Number two, lawyers do make mistakes. And when you do, you have to own up to it, and I appreciate the fact that you've owned up to it. It is, however, was a mistake. I don't believe it rises, given the fact that you were talking with your husband and you had his express consent. I don't necessarily think it rises to the level of sending it to the Attorney General's office, in part, quite frankly, because we send a lot of more serious matters to the Attorney General's office, and I like to try to handle things right here and now. So for that matter, I am going to make a motion for a letter of reprimand to conclude the case.
And would that include both Kimberly Shannon and Taylor Biddick, or?
I'm not here on behalf of.
No, that includes
the
yes.
Okay, so,
We'll deal with them separately, and that
Okay.
I may have a different opinion on that. if
all
they're
right, so
not
give me
lawyers.
the name of the defendant so I can state the motion accurately.
Taylor Biddick.
Okay, Taylor Biddick. So we're only dealing with Taylor Biddick right now. There's been a motion by Board Member Lindsay to issue a letter of reprimand for Taylor Biddick. Is there a second?
Second.
There's been a motion and a second. Discussion? Hearing no discussion, we're ready to vote. All those in favor would say aye.
Aye.
All those opposed would say no. Okay, motion carries, and a letter of reprimand will be issued to Taylor Biddick.
Except as a learning experience.
Thank you for your presentation, Counselor. You did a good job for your client, so well done. Thank you. Next, attorney on the list, please identify yourself for the record, and I think you're going to share Nadine's microphone. If Nadine is the keeper of microphone number 1. So let's, please identify yourself for the record.
Good morning, Mr. Chairman, members of the board. Nadine, thank you for the microphone and for letting me occupy a little bit of your space here. My name is Andy Welch. I represent Commissioner Lamarcus Davis. I'm with the law firm of Smith, Welch, Webb, and White, and we are here today to discuss the concerns that the board and the investigators have had with the petition signing process that underwent the election in Monroe County in 2020 during the height of COVID. Commissioner Davis, at the time running for his first time at office, was running as an independent candidate, never had run for office before. He was running against a multi-term commissioner of the Democratic Party. He obtained 210 plus signatures on the petitions. He did that with the help of his mother and his step-grandmother, is that right? And himself. It is 74 more signatures than what was required by law at the time with the COVID executive orders. Now, mind you, of course, remembering the executive orders, we had social distancing, 6-foot separation, executive orders that precluded non-family members from gathering with 10 people or more. And you're trying to go around and secure signatures during an election process to be on the ballot. And we already know that our First Amendment rights and our 14th Amendment rights entitle our citizens to engage in the electoral process and to be on the ballot, provided they follow the processes that are set by state law. During the pandemic, Mr. Davis went around and secured signatures for his petition. Prior to that, he had approached the registrar's office of Monroe County and asked for instructions on what to do in that regard. Not having done that before, the registrar's office gave him an envelope, again, social distancing, keeping separation. The envelope is here. It contained the petition, the forms that come off the Secretary of State's website. It has 3 stickers with instructions, and I'll bring it to you in a minute. I'll read them off. First, it says Monroe County Board of Elections, sticker number 1. Sticker number 2, petitions may be submitted no earlier than June 22nd, 2020 at 9 a.m. and no later than July 14th, 2020 at 12 noon.
Sorry to interrupt you, Counselor. You want the board to see that?
Oh, I do, yes.
Okay, I'm going to have Alex come up to you and
I was reading it for you.
bring that to the board so the board can have a look at that.
Yes, and then the last sticker says petitions must have 250 names of registered voters. This is the extent of the instructions that Mr. Davis was given in terms of what to do with the petitions. This is the envelope, and then I'll also give you a certified copy, Alex, if you would, of all the petitions that are in the record from Monroe County. And you'll notice that certification is particular. Certification says that these are the documents received, both front and back. And that is important because, as was Attorney Olens had mentioned earlier, the statute requires that the form that is produced by the registrar's office or the Secretary of State's office, that each sheet of a petition, the petition can be multiple sheets, but each sheet shall have at the bottom or on the back of the sheet the circular's affidavit. Now, why is that important? Well, the circular's affidavit in and of itself provides instructions on what is required. The circular's affidavit under our code section, and that's under code section 21-170 subpart D, is the requirement for the circular's affidavit to be on the sheet and on the petition, which it is not, and that's what you have before you. On that circular's affidavit, it says and gives instructions to who's circulating it. It could be anyone. Doesn't have to be the candidate. He can have people do it for him as long as they're signing the circular's affidavit, but it provides instructions. One, it says that they're duly sworn under oath, that they personally circulated the foregoing sheet, singular, and that he resides at the address below, and that he saw the signer manually sign his or her name on the sheet with full knowledge of contents, and that to the best of knowledge of belief, the signers are registered electors in the state of Georgia qualified to sign such a petition, and that their residents are the correct residences. So that affidavit provides much needed instructions that clearly the envelope does not provide. And so with that document, had that been available on each sheet, then obviously there would have been instructions to follow. And then when dispersing those petitions, if it was on the front of the petition or even on the back of each petition, then the person receiving it, whoever that may be, his mother or someone else, would know, okay, I have to watch these signatures, I have to confirm this information, and then I can sign the affidavit. None of that information is provided here. And I think the board is well aware. We have a constitution that says that we provide certain due processes of notice to each and every person that's engaged in an activity. And in that context, if a statute requires that there be language on a particular government document, and it is not there is a failure of due process in that. There's a failure, there's a vagueness, if you will, with the form, and it makes it near impossible for someone to follow the law if the form presented by the government is defective. So with that, what we've looked at for you, and there are numerous cases that we've dealt with in our state where notice and forms are required, notice to the individuals of what is being demanded presents a due process violation if it's not there, if that notice is not given. It's in the context of zoning, in the context of criminal law, in the context of state school board law, all requiring that notice be available, especially when the statute says it shall be there. So with that before you, I would want to turn to a couple of things. One is that there are two cases that I'd like you to be aware of. First, that deals with irregularities. In 1988, the Georgia Supreme Court looked specifically at a petition that had signatures on it. And in that petition, the court had found that there were some irregularities. There were signatures that weren't supposed to be on there. There were, let me get to the right page. Yeah, in Parker v. McCants, 258 Georgia 364, the election superintendent of Taylor County appealed the judgment validating a petition. There were irregularities in the petition. The petition had circulars that signed that were not, should not have signed the petition. There were electors in the petition that signed, they were circulating, and they signed the petitions they should not have. There was other defects in that petition. But the Georgia Supreme Court upheld the petition and upheld the moving forward with the ballot petition and it being voted on. And that's because they concluded that the irregularities were technical in nature, and these are clerical in this particular case as well. That the person was afforded the opportunity to be on the ballot. Now, it's difficult. What I would ask is this, is that the investigators also went through and checked the signatures that are on the petition. And I think they found a few that were erroneous. And I think the point of having that affidavit is so that when the petitioner submits it, the state, the people can have some reasonable assurance that all the signatures there were witnessed. Mr. Davis did witness signatures on some of the petitions, but not all of them. His mother witnessed some of them, but not all of them. His step-grandmother witnessed some of them, but not all of them. And so the signed oath is a signed oath that he did witness the signatures on at least one sheet. And that's what the oath requires. And our state law has been very clear, and the decisions of the Court of Appeals have been very clear, that if the oath, you can only swear to what the oath says. You can't make affirmations or declarations or swearings beyond the scope of the actual oath. And Mr. Davis, then candidate Davis, or trying to be a candidate Davis, had only sworn to the one single sheet. And that's what the oath says. And I think you may have a copy of that in your records of what the oath says in its entirety. And it only speaks to one sheet. It does not speak to multiple sheets, the whole petition, or anything of the same. And to the extent that you would like to, if you don't have a copy of it, I have a copy here for you to look at if you need that.
It's on it.
You do have it? And
We
you'll
got it.
Okay. So you'll see there that the oath itself speaks to the foregoing sheet, and it is singular. It is not multiple. With that, we would ask that the board consider the circumstances. We would ask the board consider the exact language of the statute and the oath itself. And that in your wisdom, we would ask that you look at a letter of instruction to Commissioner Davis. I don't think that this is going to ever be a problem for Commissioner Davis now that he's an incumbent. But I think that to the extent the board needs to make a public statement to the commissioner and to the public as a whole, that each and every form must be signed with the circulator's affidavit, that does make sense to us. With that, I'll close and ask that I hope you do not penalize Mr. Davis for what amounts to be a clerical problem with the form. Thank you.
Thank you for your presentation. Comments or questions from members of the board?
Yeah.
Mr. Lindsay has the floor.
Thank you. You know, there are two very separate issues here. One is whether or not there's enough petitions here to put him on the ballot. And then there's and there's no question about that. The second question is whether or not he, in obtaining the number of signatures, engaged in an irregularity that made it more difficult for the registrar to determine whether or not he should be on the ballot. And therein lies the problem. If I understand correctly, this is the only sheet that he submitted. Is that right?
That's correct. When he went to the office, she asked him to sign that,
Yeah.
that single sheet.
So it was either so it either led her to believe that he had in fact actually personally witnessed all of the signatures, rather than the technicality that the word sheet is singular rather than plural. And therein lies the difficulty that we have here, in that by virtue of how he chose to do so, all he really had to do was to get his wife?
Mother and step-grandmother.
Mother and step-grandmother to also sign on would have assisted the registrar determining that these were in fact a valid petition. And therein lies the problem, with simply dismissing the case.
Yes, may I respond,
Yeah.
Mr. Chairman? Yes, I do believe that the candidate-elect Davis did communicate to the registrar's office that other people were helping with the circulation of the petition. So I don't think there was there's nothing intentional about it. There certainly wasn't anything knowingly, because the certificate's not on the forms. And in addition, he disclosed that to her. And I think this was part of the questions that were trying to be relayed back and forth and get instructions from the Secretary of State's office, but it was COVID. I mean, it's just near impossible to make those contacts. And it made it difficult, but it surely was.
I do recognize, I didn't mean to cut you off, I do recognize that this certainly does appear to be some additional need for instructions to be given to both the candidate and to the local officials on how to handle these petitions. That's very clear and abundant. But given the fact that we've already seen one irregularity and we're likely to see a couple of others, this sort of adds to the importance of having the person who witnessed the sheet to actually be the one who signs off on it. I think what had happened here sort of shows why that's so important.
Mr. Lindsay yields the floor. Member Gazelle has the floor.
Thank you, Mr. Chairman. Did Mr. Davis have any formal advisors in this process? Did he secure an attorney or anyone to help with this process?
No.
So he did it all on his own?
This was a do-it-yourself DIY.
And there were no further instructions aside from these stickers? And that's all the guidance that you received? When you turned this in, did you get any other feedback from the registrar's office about the completeness of the petition package?
No, ma'am, not to my knowledge.
Thank you. I don't have any other questions.
Member Gazelle yields the floor. Dr. Johnson, would you like to be recognized?
Yes, Mr. Chairman.
Dr. Johnson has the floor.
The issue, I probably agree with my colleague, member Mr. Lindsay, that somebody needs to attest to the signatures that are obtained with petitions. So the technicality of signing for one sheet is okay, but then someone needs to sign for all the other sheets and to attest that these are true and accurate qualified voters, electors. So that's the issue. It's sort of like you can't have it both ways.
Dr. Johnson, I couldn't agree more. That's what the statute requires. But it needs to be on the form. The statute mandates that it's on the form, and that's our problem. We have a form that when you go to the Secretary of State's website and you pull it up, it's a two-page form. They're separate. And so if you're circulating the petition, you hand the petition form out, which is what you have before you, and it doesn't have it at the bottom, which the law mandates, or on the back. And frankly, I would prefer that it be on the front of the page, because that way if you photocopy it, somebody doesn't make another clerical error, which is they don't photocopy both sides, right? So if it's photocopied and it's on the front, it's clear. And so I do understand what you're saying, Dr. Johnson. I think under these circumstances, it truly is a mistake, and it's a clerical one on sort of a group effort, unfortunately. One other thing is I do think it's important that in the process of investigating this, it's my understanding that the investigators went through the signatures to determine if there were forgeries there. And so what they have found was that out of the 210, I think there was a handful of those that had that affidavit been on there, on the form, then those things I think would have been eliminated, those problems would be eliminated. Thank you, Dr. Johnson.
Dr. Johnston yields the floor.
Yield the floor.
Okay. We've now reached a chance where all the board members have had a chance to ask comments, ask questions, make comments. We're ready for a motion.
One last comment, Mr. Chairman.
Okay, Mr. Lindsay has the floor.
It's apparent that we need to clean up this process, and that in terms of making sure that folks running for office, folks administering the office, and folks being asked to sign off on a petition have a much clearer understanding as to what they can and cannot do. I have a difficult time necessarily faulting the candidate or the registrar for a mistake when there wasn't any clear instructions given. And for that, but that being said, I do think at least a statement needs to be made that this, because that this sort of thing cannot happen again. I don't think it will happen again. And so I would move for a letter of instruction. And I hope my friends at Secretary of State's office are here to go back and figure out a way to make sure that this is clarified for folks trying to run for office, because my suspicion is this will not be the last time someone decides to run as an independent. And we need to be able to have folks be able to go through the process without there being some kind of unforeseen landmine out there for them. So for that reason, I moved for a letter of instruction.
Okay, there's been a motion made for a letter of instruction. Is there a second?
Second.
There's been a motion and a second for a letter of instruction to be issued to LaMarcus Davis and Barbara Davis. Any discussion? Hearing no discussion, we're ready to vote. All those in favor would say aye.
Aye.
All those opposed would say no. Motion carries.
Thank you, members of the board. Thank you for your time and service.
And Counselor, unless anybody else in this case needs your input, you are excused, and we have your evidence here. You're free to go.
Can I ask that you turn off this mic from the guy who was here before me?
Wait a minute.
Don't want it to just sound conversation.
Wait.
And disregard what I said about the SOS.
You got it.
All derogatory comments overheard by the meeting are stricken from the record. Okay. Thank you for bringing that to our attention. I'll check and make sure that nobody's got an open mic but the board right now. Thank you for bringing that to my attention. Okay. In this same case, we have Lakeisha, I hope I'm pronouncing that correct. Ms. Furlow? Okay. If somebody would make available a microphone for Ms. Furlow, would you like to join the microphone one? Nadine's been a true public servant today, providing the microphone. I'll turn you on. And if you identify yourself for the record, please.
My name is Lakeisha Furlow.
Lakeisha Furlow.
That's
Lakeisha,
correct.
Thank you. Welcome.
Thanks.
Floor's yours.
Okay, basically on the
They're going to ask you to speak up.
Okay, well, basically on the petition, I did accidentally put my name down twice. In error, it wasn't anything that I deliberately tried to do. And so when the investigator came out, they did point it out to me. And I wasn't sure how to correct that. So basically, he just told me to put a line through it and initial it, and that's what I did with no problem.
Okay. Questions from the board?
Let me get this straight. You simply signed your own name
My own name, yes.
twice,
Yes.
which was clearly your own name twice.
Yes, my name.
So
No
that
one else
anybody
name.
who was going through it could see that
My
you had-
name
had
spelled
been
the same way,
signed.
exactly like I do, write it. So no one else's, mine.
At the appropriate time, Mr. Chairman, I have a motion.
Okay. Other questions from the board? Mr. Lindsay has requested the floor for a motion.
Inasmuch as clearly, if you were engaging in fraud, you did a very poor job of it.
I would never.
And you
Not
weren't.
myself,
No, ma'am, understand, I'm making a joke. Okay, and I hope you took it that way.
I did, I really did.
You know, that clearly, if anyone looked, and folks who did look at the petition, and I think the registrar even mentioned that they saw some
Right.
irregularities in terms of people, that sort of thing. There's no fraud here, and there's no intent here, and there's no attempt to sign someone else's name.
Correct.
And you're clearly not an attorney. Well,
Correct.
I understand you're
I'm
not an
not.
attorney. I understood earlier that you weren't one. So for that reason, I moved to dismiss.
Okay, all right, thanks.
There's been a motion to dismiss. Is there a second?
Second.
There's been a motion to dismiss and a second. Any discussion?
I'd like to ask Ms. Furlow, do you know that in the future, you should not sign the same petition twice?
Never. Lesson
Never.
learned. That won't even happen again.
We don't vote twice, and we don't sign petitions twice.
Right.
Okay,
Lesson learned.
thank you.
Thanks.
Okay, so there's been a motion and a second. Any further discussion? Hearing none, we're ready to vote. All those in favor of the motion to dismiss Lakeisha Furrow would say aye.
Aye.
All those opposed would say no. And motion carries unanimously. And my records show that I still have Kimberly Shannon open. Are you Kimberly Shannon? Welcome. If you'll step up, please. If you please identify yourself for the record.
I'm Kimberly Shannon.
Okay. You have any comments to the board that you'd like to make?
No, sir.
Okay. Any questions from Ms. Shannon from the board?
If I may, because it's been a number of people, what were the allegations against? And I apologize, I just got to flip through and find it.
The allegation was that she signed her family members' names on the petition.
So, Ms. Shannon, the Secretary of State's investigators have reported that there were 3 citizens, Prentice Shannon, Bree Shannon, and Wanda Shannon, who denied having signed the nomination petition, but their names were on it. So, do you have any information that you could give to the board to explain what happened?
No, I do not recall signing their names, but I know if I would have called them and asked them, they would have gave me their permission.
Mr. Lindsay looks like he's going to want to have the floor in a second, so
Yeah.
we'll give him a second to study. Dr.
Why do you
John-
think that your
Mr.
family has
Lindsay.
denied either signing the petition or wanting to sign the petition?
They advised that they asked, did they sign the petition? But if I were to call them, they would have said, that's fine.
To my investigator, did you ask that second part of the question regarding the family members' willingness to sign the petition if they've been asked?
I don't believe they asked that. They just asked if they signed the petition. They said no.
Yeah. And Ms. Shannon denied that she signed the petitions of her family members, correct?
Pardon me?
Ms. Shannon denied that she had signed the petitions of the other family members, correct?
Yes.
See, Ms. Shannon, therein lies, quite frankly, a more serious aspect. You know, as we've seen, you know, when people come here and they admit they made a mistake, and quite frankly, in some cases, are here with their family members who said that they had consented to them signing it. You know, we're far more willing to dispose of the matter quickly. But in this situation, you made the role of the investigator all the more harder because you denied even signing the petition when
I
clearly
told him I didn't recall. He came over twice, and I had to fill out a form the second time.
You hold the microphone a little bit closer, please.
He came over twice, and I had to fill out a form the second time, advising that I did not recall.
Okay.
Mr. Prentice did make the statement, though, that he would have signed had he been asked to. He would have signed it, though, for Mr. Davis.
Investigator Carr, were the signatures the same on the petition?
They appear
Was the
so.
handwriting the same?
Yes, they look the same. Do you want to see him?
Yeah, I'll pass this down. Okay, Mr. Lindsay still has the floor. Okay, any questions or comments from the board? At this time, the chair is ready to hear a motion, if there's one to be made.
Mr. Chair,
Member Gazelle has the floor.
I move that we refer this to the Attorney General's office. I think there is sufficient question of fact remaining here that I'm not satisfied.
Okay, there's been a motion to refer to the Attorney General. Is there a second?
Second.
There's been a motion and a second. Discussion? Hearing no discussion, we're ready to vote. All those in favor would say aye.
Aye.
All those opposed would say no. Okay, the motion passes. The matter be referred to the Attorney General. And according to my records, that completes this case. Does anybody have anything that says that's wrong? Everybody agree that that completes that case?
I agree.
Okay. The board agrees that that case is dismissed, not dismissed, but that case is completed. So the Monroe County nomination petition, SEB 2020-263, is closed and all aspects of it have been resolved. With regard to housekeeping, I should have announced that case number SEB 2020-292, Richmond County voter registration, SEB 2020-292, Richmond County voter registration, that case has been continued. Okay, if anybody was here for Richmond County case number 2020-292, you're free to go. That case has been continued to the next calendar. Okay, at this point, we will move to the public comment section of the meeting. I'm going to ask that you keep your this has been scheduled for 1 hour, so I'm going to ask you to keep your comments to 2 minutes apiece, because if you go over your time, you will be cutting off somebody who wants to speak, who won't get the chance to. So please, okay. A couple of points to remind everyone about public comment. It's limited to 2 minutes. It is free to the public, so you will hear public comments that you don't agree with. And so everybody is to treat everyone here with respect and dignity that they would like for themselves. And so there is no cheering or booing or comments made to the public comment. The citizens are free to make their comment without harassment or intimidation or statement otherwise. Also, the board does not answer questions during public comment. This is your time to be heard. The board will not answer questions, so all questions posed to the board are deemed to be rhetorical in nature, and the board will not answer. So with that, we'll begin our public comment session for 1 hour, beginning with George Balbona. The floor is yours. Thank you, sir. The floor is yours for 2 minutes.
I'll try to be quick.
Your
My name is George
microphone is
Balbona. I'm
on.
from Cobb County. I just want to go over a few things. Last year, Georgia County spent nearly $3 million just to have their Dominion hardware warranty agreements. Fulton County spent over $500,000. DeKalb County spent $418,000. right? Top two. Can you hear me? Sorry about that. I should know better. All right, so how much do you think Gwinnett and Cobb paid? 54 and almost 42. That's nearly 10 times less. Huh. It's because they didn't have their touchscreens on their account. So that's something they can do. I wonder if Fulton and DeKalb knew anything about that. So 84 counties have complete coverage, 49 counties have no coverage, and 26 have partial coverage. These are their crazy amounts for the units and the amount to have them on the warranty. Dominion reserves the right to adjust the annual hardware fee within 3% of the current fee. They exercise that right. Same coverage is going to cost Georgia $90,000 more this year. What's funny is if you look at their contract that they send out to the elections directors, it says that by enrolling in the initial extended warranty and renewing consecutively each year, the customer is guaranteed this price for the balance of the 10-year contract with Georgia with no price increases. I guess they forgot that part. All right, so they jacked up a lot of stuff. Memory cards went up 25.7%. USB flash drives went up 36.48%. Really, those are the highest hikes, and it happens to be on that. If you look at just the 4 items that are covered by the Dominion hardware warranty agreement, HWA, $70.5 million worth of equipment. Yeah, but that doesn't cover everything, because there's ICC units. Those are the central scanners. They cost $25,000 a pop. Every county has at least one. 143 counties have one. All right, there's 8 counties that have 2, 3 counties that have 3, and 3 counties that have 4. That would be Fulton, Cobb, and DeKalb. Clayton has 6. Not sure about that one. But even crazier, Gwinnett County has 9 that they used last year, 2022. But they actually own 23, which boggles my mind. Why? Why do they have 23? There's no rational reason for that. Why don't we ask the SOS? Because they approved it. All right, so there was a bill a while back to have Georgia counties adjust the number of BMDs, that's the touchscreen, deployed on election day based on early voting ballots cast. It didn't pass, by the way. All right. Nonetheless, only 8 counties deployed all 100% of their touchscreens in 2022. The amount that the BMDs that weren't deployed in 2022 on election day, 11.6 million, just sitting around. All right, so if you look at the appearance versus the reality, you have the total number of BMD units, and that should be, the law is 1 per every 250 registered voters. If you look at that, it looks pretty good. You only have 11 counties that are violating OCGA. But if you actually look at the units that were deployed, the fact, on election day, that jumps up to 103 counties violating OCGA. And some of them, 8 of them.
Thank you, Mr. Bellamy. Thank you.
2 minutes goes awfully quick.
It does, doesn't it?
And I've spent months doing research for you guys.
I know, you always do. Thank you for your comments, Mr. Balbon. Thank you for your comments, Mr. Balbon. The next will be David Callahan. The floor is yours for 2 minutes.
David Callahan from Fulton County. In 2021, I worked the municipal election, and I had a gentleman, we'll call him Vance. He came to my window and he wanted to make sure that he was still registered to vote. When I checked, I found out that he was, yes, still registered to vote. He actually had 3 voter registrations, although one of the 3 had been canceled. As I looked further, I found out that the other 2 registrations that he had been voted in the 2020 presidential election. Now, I'm not accusing him of voting both of those. I'm just saying there were 2 registrations and both of them were voted. All 3 of those registrations had the same driver's license number, had the same social security number, had the same date of birth. What I really want to know is how the Secretary of State's office can allow duplicate registrations. As I dug further, I found page after page after page of duplicate registrations in Georgia at the same time that there was an election going on. There were my understanding, there were 20,000 registrations that were canceled between the 2020 election and the 2021 municipal election. So I filed a FOIA request asking how many of those ineligible registrations were voted in the 2020 election. The response I got was that we do not keep that data. I find it very disturbing that our voter rolls are so dirty. I find it very disturbing that people can have multiple registrations and vote on multiple registrations, or have them voted on multiple registrations. I also, when I knocked on doors, I went to the home of a Jehovah's Witness pastor. I don't know if you know, but the Jehovah's Witnesses do not vote by their religion. This pastor explained to me why they don't vote. But then I knew he was registered to vote because that's why I was at his door. And then I found that somebody had voted his registration.
Thank you, Mr. Callahan. Thank you for your comments. The next commenter will be Sean Cross, it looks like.
Hi, I'm Sean Cross. On October
The floor is
11th,
yours for 2
I'm sorry?
minutes. The floor is yours for 2 minutes.
Thank you. On October 11th, 2022, Kevin Monkla and David Cross requested an emergency review by you of 2 issues found in 65 of the 67 Georgia counties that they obtained records from: the voting machine QR code signature mismatch and ballot format or ID unrecognizable error pair is a triggering event for an error known as the Williamson incident. The Election Assistance Commission validated this error in Dominion machines. A second error was identified when a voter attempts to scan their ballot. The scanner returns it to the voter, but then accepts it. Their investigation revealed the same rejected, then accepted pattern occurs in concert with several other errors and at an alarming volume affecting approximately 20% of all ballots cast across the state of Georgia. Please help the citizens of Georgia understand why we are voting on machines that have errors validated by election officials and citizens. Fair, legal, and orderly elections are the board's watchwords for your service to the people of Georgia. You are committed to the highest standards of integrity in your service to our state and its citizens and all matters related to the election process. These are the values to which you commit. It is your responsibility as the State Election Board to investigate and correct this. Why are you and the Secretary of State continuing to ignore this nefarious condition? This is a violation of Georgia Code, a violation of your oath, and in addition to you failing the citizens of Georgia. Thank you.
Thank you for your comments. Janelle Clodfelter. Hope I pronounced that correctly.
Yeah, Janelle Clodfelter Unplugged.
The floor is yours for 2 minutes. Plugged or unplugged?
All of this information, research, SEB meetings, legislative committee meetings, press conferences, lawsuits, etc. I've been paying attention and I can no longer ignore. At a previous SEB meeting, John Paulus testified, to verify tabulators, the best thing to do is count the ballots. They are what is not hackable. What is hackable? Am I supposed to ignore that comment? He testified here. Expert Alex Halderman reports that machines must go because people like me can hack them. And he stated that the machines we have were not designed for security and can't be retrofitted. Should I ignore that? Gabe Sterling testified before Legislative Committee. Machines do what we tell them to do. Well, I agree with that, but the machine software is proprietary. How do you audit that? Mr. Sterling testified that the SOS supports more audits. If that is the case, why has the SOS done everything over the past 3 years to prevent the audit of 150 pristine Fulton County ballots? And why has he written magical legalese letters to county boards preventing attempts to audit? Should I ignore that? Legislators in committee state our vulnerabilities have been announced to the world. Should I ignore that? What has happened with the no-ink poll pad issue has set us back a year, and we can't update software to address the vulnerabilities that have been announced to the world. One of the legislators stated he would cancel the contract if this were his own private company. Why can't we cancel it for we the people?
Thank you, Ms. Gladfelter.
Okay.
Next speaker is Tim Waters. Tim Waters. The floor is yours. Tim Waters, 2 minutes.
Thank you, Mr. Chairman.
You're welcome.
So, with regards to the delay in SEB 2023-025, justice delayed is justice denied. And I want to speak of the errors, the lie, and the cover-up. The errors. At this point, it is indisputable that the errors exist in the RLA hand audit report for Fulton County posted on the Secretary of State's website. 36 errors were identified in this report by the Rossi James team. The totality of these errors netted Biden 4,081 false absentee ballot votes out of 147,000 absentee ballot votes counted. That's a 2.7% error rate. These errors were validated by the governor's team, by Governor Kemp's team. In the governor's letter, two important statements are made. 36 errors noted by Mr. Rossi are factual in nature, and data that exists in public view on the Secretary of State's website on the RLA report does not inspire confidence. It is sloppy and inconsistent. Post-Governor Kemp's letter, with their backs to the wall, Assistant Attorney General McGowan's, SOS investigator Zagor, and SOS Attorney Ryan Germany, the SEB, Fulton County, and even Mr. Raffensperger himself had to admit the Fulton County hand audit was erred. During the radio interview dated on 2/22/22, Mr. Integrity states, "When we did 100% hand recount, we found 3 counties that messed up. You know, fairly significant. Number 2 was Fulton County. All of a sudden, they were off by several thousand ballots. Well, it's because you scanned some of these ballots twice." Does integrity count?
Thank you, Mr. Waters.
Thank you.
Next speaker is Lisa Neisler, either Neisler or Neisler. Lisa? Lisa Neisler or Neisler?
It's Neisler.
Neisler. Lisa Neisler. 2
Yes.
minutes. Your floor is yours.
All right, thanks. Well, I'm going to speak about the lie, and I'm going to start by talking about the email from Gabriel Sterling's office, from the Secretary of State office, and where he states, "We know with 100% certainty that the ballots, 100% certainty, that the ballots were not tallied multiple times because the hand tally shows that." Flash forward to the first quarter of 2022, when Raffensperger admits Fulton doubles counted thousands of ballots. And in his radio interview, with his back to the wall, after Governor Kemp's stunning rebuke of the Secretary of State's so-called accurate hand audit, in that statement, he admits to significant ballot counting errors in Fulton County. And I'm just going to quote again what he said was, "When we did the 100% hand recount, we found 3 counties that messed up, you know, fairly significantly. Number 2 was Fulton County. All of a sudden, they were off by several thousand ballots. Well, it's because you scanned some of these ballots twice. That's how that got messed up. Fulton County, though, continues to mess up. The RLA hand audit for Fulton County posted on the Secretary of State website cannot be both 100% certain and off by thousands because they were scanned twice. You can't have it both ways. Thank you.
Next speaker is, thank you for your comment. Next speaker is Amanda Prettyman. The floor is yours for 2 minutes.
Thank you. All right, well, let's talk about the cover-up. The errors and the lie are bad, but what is worse is the cover-up, an effort by the Secretary of State's office, the Attorney General's office, and this state election board to work to exonerate the Secretary of State of any responsibility for his errored recounts. On December 4th, 2021, there's an unsolicited phone call from Ms. McGowan, Assistant Attorney General, to complainant Jack James. James transcribed notes from the call which state, quote, "The purpose of her call was apparently to convince me that the Secretary of State has no responsibility for the errors exposed in Fulton." On December 16th, 2021, there is a Secretary of State investigator meeting in which Investigator Zagarin says to complainant Rossi, quote, "I think you are saying because it's on our website, it's our responsibility." In the March 16th, 2022 State Election Board hearing on SEB 2021-181, whenever complainant Rossi brings up the issues with the Secretary of State, he is shut down by Acting Chairman Mashburn, who states, "All right, Mr. Rossi, I'm going to have to caution you again. Fulton County is the respondent. This is not a hearing about the Secretary of State." There is one more shutdown that took place on July of 2023 by none other than Ms. McGowan, who moved over to become the Secretary of State's attorney. This shutdown involves an investigation case against the Secretary of State for election code violations, SEB BI 2023-0001. This case will be discussed today and is arguably the most important case before the board. I hope that you will hold the Secretary of State accountable, for no one is above the law in a democracy and in this republic. And that includes the Secretary of State. And if you don't hold him accountable, who will? Is he accountable to no one, or is he accountable to someone? Thank you.
Thank you for your comments. The next speaker is Joe Rossi.
Give me a second to get situated, please.
Okay, we won't start you till you get situated, Mr. Rossi. Let me know when you're ready.
I'm ready,
Ready?
sir.
All right. 2 minutes. The floor is yours.
All right. Good morning, board. Good morning, fellow Georgia patriots. SEB BI 2023-001, perhaps the most serious case that I can think of before the board. And to verify that, I'm happy to say that Mr. Mashburn agrees it's fairly serious also. And thank you for that, Mr. Mashburn. Thank you for this letter. To remind you, this case, as mentioned earlier, is one of a kind. It is whether the board has the authority to investigate the Secretary of State for election code violations. If the board doesn't do it, who can? But again, the seriousness of it. Mr. Mashburn sends me a certified letter in October of 2023. He says, there was no deadline for when the board would decide the matter. That's the only thing I disagree with you on, Mr. Mashburn. Sometimes deadlines are important. But he does say the matter would be diligently, thoroughly, and responsibly considered. Then he goes on to say the matter is one that is unprecedented in Georgia history. So let me move on and remind the board, y'all have already opened up a case on this. As a matter of fact, y'all know Chairman Duffy, right? He opened up a case in July of 2023, only to be shut down by none other than Ms. McGowan, Raffensperger's attorney. How do I know that? I got this email from Chairman Duffy, August 6, 6:23 a.m. on a Sunday morning. He must have been troubled by it to do it that early, right? I'll tell you what's in the body of the email. But more importantly, this is Ms. McGowan's attachment. He didn't have to send me the attachment between her and him, but he did, obviously troubled by it. In the attachment, Ms. McGowan says, Judge Duffy, I understand that you have asked Sarah to open up a new case on Mr. Rossi's complaint against the Secretary of State's office regarding the posting of the county-level RLA results for the 2020 election. I have instructed our investigations division that this office will not be opening up a case on this complaint for several reasons. And finally, at the end, I don't know if this was a threat or an instruction, but I don't think Judge Duffy took it too well. It says, I trust with this information that the board will inform Mr. Rossi that no case will be opened on this matter. And finally, Mr. Duffy, he did not accept that shutdown. Thank him for that. And now it's time for the board to move on. He says, in an email to me, we are evaluating our options on how we can proceed in this matter. So I would ask the board to build public confidence back into our elections, specifically the Secretary of State's office. I want to remind you what Governor Kemp said. The data that's posted on the Secretary of State's website for the RLA report is sloppy. It's inconsistent and does not build public confidence. The board has an opportunity to put some public confidence back into our election office by voting yes on BI 2022. Thank you for your time.
Next speaker is David Cross. David Cross. If you'll let me know when you're ready.
All set.
All set.
Mr. Rossi.
The floor is yours.
I appreciate your work, and I appreciate you continuing my work and the work of other folks here. For today's SCB meeting, we're supposed to hear the details of SCB 2023-025 regarding the errors in the second machine count, which revealed 17,852 missing ballot images and 3,125 duplicate counted ballots in Fulton County. The case was categorized as violations found to be referred to the Attorney General's office for further action. On Friday afternoon last week, at around 4:30, Mr. Rossi was notified by email by the SCB's paralegal that said, "Good morning or good afternoon. Please accept this email as notice that case SCB 2023-025 has been continued from the agenda and will not be heard on the December 19th SCB meeting." So what happened? So per the SCB paralegal, board members are provided a case review package approximately a week in advance of these meetings. Somehow between the receipt of the review package and this past Friday, the item was pulled from the agenda. Could it be that the review package contained an inadequate report on the case by the investigative team? Was it going to be another attempt by the Secretary of State's office to move this case along and push it under the rug and get it closed out with minimal damage to the Secretary of State's narrative that we did count 3 times and everything was accurate? The bottom line is this is a serious case, and the public deserves answers as to why this case was pulled and what are the next action steps regarding 2023-025. Investigators took 10 months to deliver an incomplete report that one can only surmise the case was not discussion ready or ready for investigators to discuss or have the expertise to be able to discuss it. We, the people, demand answers. We want to see the investigation reports because we have no confidence in the investigation process.
Next commenter is Bob Couvert. Couvert? Did I pronounce that correctly?
That's correct. Bob Couvert, Blue Ridge, Georgia.
Couvert, welcome.
Thank
2
you.
minutes. The floor is yours.
Thank you, sir. Most people in here are very familiar with the Ligon report that came out in December just following the election of 2020, especially my friend Sam back there. What he said in that was, there is ample evidence that this cannot be certified. Now, why is that important? Because Judge Ligon, Senator Ligon, was a judge for 16 years in Brunswick, Georgia. If anybody knows what evidence looks like, it's Judge Ligon. So shortly after that, on December 22nd, Secretary Raffensperger had a press release that said, "I'm bringing together all of government to go after 250 credible cases of fraud in the state of Georgia." 250 credible cases. 2 weeks later, he went to the United States Congress. He wrote a letter to Vice President Pence, all the members of Congress, and said, nothing is wrong in Georgia. There's no fraud. In 3 weeks, we solved all these 250, at that time, known issues of fraud. So you tell me where the fraud is. Many of us, including some attorneys, looked at the letter, a 10-page letter to the U.S. Congress. It had 42 false statements in it. Our Secretary of State told 42 false statements to the United States Congress and the Vice President. So within that document was the Pro V&V audit. He told us, the citizens, he told the SEB, he's told many courts that this Pro V&V audit took place. I worked with Governor Kemp. I worked with Evan Myers, one of his attorneys. I worked with the Inspector General, Scott McAfee. And they tried to convince me that the Secretary of State and Pro V&V told them that this audit took place. Well, I asked them, how many counties told you the audit took place? 0. We did open records requests to the counties, and it came back where 0 audits were done by Pro V&V. So now we're making decisions, our legislators are making decisions on an audit that never took place.
Thank you for your comments. Thank you. Marybelle Hodge. Marybelle Hodge. Marybelle Hodge. Welcome. The floor is yours for 2 minutes.
I'm ready.
All right.
So when a person convicted of a felony loses their right to vote, they can lawfully restore that right by completing their sentence, their parole, pay their fines, and deliver paperwork in person to the elections office. I'm certain the board's aware of this. We are discovering ongoing manipulation of voter IDs of felons in Georgia. In 2022, voter IDs of felons were used to cast votes, and then immediately after the election were canceled and removed from the rolls. Some of them were canceled November 4th, 2020, less than 24 hours after the election. This is clearly identity theft that could cause serious ramifications for felons who would desire to restore their right, and they are unaware this is going on. Let me tell you about Mr. Hickman. Mr. Hickman appeared on the Gwinnett voter rolls in April 2023 with a registration date of April 28, 2023, and an address of 3900 Satellite Boulevard, Duluth, Georgia. This is a non-residential address. I challenged this voter in Gwinnett County due to the non-existent non-residential address. On August 16th, 2023, Mr. Manifold, election supervisor, responded via letter stating, and I quote, "The challenges will not be scheduled for a hearing because both voters are no longer on Gwinnett County Register voters. Mr. Hickman registered in Muskogee County on April 28, 2023, end quote. A quick review of the data is remarkable. April 28, 2023, registration for Mr. Hickman, Muskogee County, 3900 Chautauqua Road. May through August, voter roll registration address, 3900 Satellite Boulevard, Duluth, Gwinnett. Mr. Hickman was and is currently incarcerated at 3900 Chautauqua Road, Columbus. Who is manipulating these voter IDs? These felons do not know it. Has someone made Mr. Hickman aware that he has been registered in several counties more than once while he's still incarcerated? How could the Department of Driver Services send a motor voter application to Gwinnett County with an inaccurate address from an individual who's sitting in jail in another county?
Thank you, Ms. Hodge. Thank you.
Thank you. Unjust waits is an abomination to the Lord.
The next speaker is Ben Eskew. Ben Eskew. Ben Eskew. Take your time. Welcome. Floor is yours for 2 minutes.
Okay. Hello, my name is Ben Eskew. I want to share some election trends from the Republican areas of the Atlanta suburbs where trends may be a bit off the line. The biggest off trend is in North Fulton County, which has been a Republican stronghold for a very long time. Until the safest and most secure election in history, when you combine the 5 cities north of the Chattahoochee River, Joe Biden won that area by a 51-47 margin. According to my estimates, that is the first time a Democrat won that area since Harry S. Truman did in 1948. It even voted for Gerald Ford in 1976, according to my estimates. I do not have precinct data before 1984. I do not know if I can get it by ORR in Fulton County for that data. But anyways, it's just shocking. According to my estimates, these are just, I get this from other counties' data, like surrounding data, because I get county data back to the early 1900s. He became the first Democrat since Carter to win Roswell, Stevenson to win Johns Creek, and FDR to win Alpharetta. I'm not sure, based on this data, if I have the precinct file, because I have it back to 1984, because I got it via a online source. And we're going to go to some other counties, mainly Cobb County and Gwinnett County, which again have historically been Republican counties, until Hillary Clinton won them in a major upset in 2016. They last voted Democrat for Jimmy Carter in 1976 when he swept every county in the state. In Gwinnett County, I'm a Gwinnett County resident, by the way, what seems suspicious is every office flipped from Republican to Democrat in the 2020 election cycle, one election cycle. It usually takes counties a few election cycles to flip from one party to another. Republicans won most of them unopposed in 2016. I understand that Gwinnett's been changing, but it makes no sense. Get ready for this. Donald Trump received more votes than George W. Bush did in Gwinnett County, despite him, Bush winning the county by a 2-to-1 margin and Trump losing it by 18 percentage points.
Thank you, Mr. Eskew. Thank you.
My time's up. Thank you very much.
Thank you. The next speaker is Jeff Fulgham. Jeff Fulgham, I hope I'm pronouncing that correctly.
Yes, sir, you did. Thank you.
You have 2 minutes. The floor is yours.
Thank you. My name is Jeff Fulgham. I live in Fargo, Georgia. I'm retired military, and I served 20 years in the military, and I have 14 years of experience as a research historian. In December of 2021, I filed a fraud report with CISA, the cybersecurity agency of DHS, concerning Fulton County 2020. I then briefed the FBI on this report on 3 occasions. What I told the FBI was that I believed that the duplicate batches that Mr. Rossi proved were actually entered intentionally. They had been altered and then duplicated. And I did 6 months of research on this. Following my discussion, these were 6,000 gross fake votes added to the Fulton hand count. Following my discussion with the FBI, 2 months later, the Georgia Secretary of State made the following admission. He said that the Fulton hand count was actually off by several thousand because they scanned ballots twice. Immediately after that, though, at the March hearing here at the State Election Board for the Mr. Rossi hearing, the investigators concealed that evidence from the board and the people. So I then filed my second fraud report, this one with the AG, who also buried this evidence. Now I filed a complaint with the Office of the Inspector General, and I have requested that they investigate the Georgia Secretary of State as well as the AG for mishandling and concealing evidence from 2020. And if the media would like to look into my complaint with the IG, the complaint number is 71933C143F, and my last name is Fulgham, Fulgham. Thank you.
Thank you, Mr. Fulgham. The next speaker is Helen Strahl. Helen Strahl. Hopefully I pronounced that correctly.
Yes, you did. That's great. Thank you.
The floor is yours, 2 minutes.
Thanks. Good morning, everybody. Several data analysts have studied the Secretary of State 2020 voter rolls, the absentee ballot files, and the voter history files. This analysis reveals hundreds of thousands of unlawful ballots. During 2019 and 2020, the law said you could not request an absentee ballot earlier than 180 days prior to an election. That was May 6th in 2020. There is a well-established process for processing early ballots, but it was dramatically changed in 2020. The Secretary of State told all 159 counties that he was going to take over the ballot request process until sometime in mid-September, because he was going to do a mass mailing, and he did, September 18th. At this point, you need to realize that no county official across the entire state was involved in the early ballot process, either with the issuance, the acceptance, until sometime in mid-September. This is key. The county officials knew nothing about this. Starting in January 2019, yes, January 2019, the ballot requests were coming in for the November election in large batches, with an almost 100% acceptance rate. This is a year and a half before the election. Says no human ever while wrapping Christmas presents in 2019, I think I'll request a ballot for next year's election. That didn't happen. Deals were made. March 2020, COVID hit. Drop boxes were created and absentee ballot rules were relaxed without the state legislator's authorization. The number of unlawful early ballots was over 250,000, and they were turned into votes.
Thank you, Ms. Strahl. Thank you for
How
your
do you
comments.
hide them?
Thank you.
Thank you.
Lisa Rutherford. Lisa Rutherford. Lisa Rutherford.
Thank you. I have personally been before our Gwinnett BRE many times over the past few years. They know me well. You've already heard plenty of disturbing information today on election issues. In August of 2020, a gentleman in Gwinnett sold his home, and we know this from the deed of sale and canvassing, and he moved and purchased a home in North Carolina. Yet he submitted an absentee mail ballot request to the NCOA address and voted illegally in the 2020 and 2021 elections, thereby voiding a legal vote. We challenged this voter, along with many others, in 2022 with sworn affidavits and documentation, but they were dismissed without review by our BRE. October of 2022, we alerted the board and staff this voter and others were again requesting absentee mail ballots to the same out-of-state addresses they had been made aware of earlier. No action was taken to determine if these requests are legitimate. It's a literal free-for-all with no checks and balances on your end. The absentee mail ballot was easily mailed to him, and he again voted illegally in this past election, attesting under penalty of law that he still resides at the home he sold years before. This is not an isolated incident, and we bring these before the board often. I challenged this voter again in September with over a dozen irrefutable data points of proof, affidavits and canvassing, deeds of home sale and purchase, SOS corporate division information, your own SOS data from his voter history, a professional location report widely recognized in the court system, and much, much more. This information would rival anything you would receive from your investigators here. However, our board voted down party lines, and the result was no action taken, so he is still active on the roll today. I believe this breached their oaths of office. I was looking to see if any amount of evidence would yield a favorable outcome, and 2 board members failed miserably. In the next breath, a motion to send the challenges to you for further criminal investigation passed, so they would not make the right decision, but they want you to. Will you do the right thing now, since they wouldn't? many cases that go before you end up in a black hole. I'll be watching to see if he and others vote illegally again this year. I will now hold you accountable as well. Remember your oaths. The evidence demands a verdict.
Thank you, Ms. Rutherford. The next voter is Sam Cardine or Carnine? Carnine. C-A-R-N-L-I-N-E. It looks like a D is in there, I'm sorry. That's all right. Cairo, Georgia.
Cairo, Georgia.
The floor,
Thank you, Board.
The floor is Cairo, Georgia's for 2 minutes.
Down in Cairo, Grady County, we grow cotton, peanuts, and pine trees. You can make lots of paper ballots out of the pine trees in Grady County. Thank you, Board, for hearing me today. Thank you all for showing up. Members of the State Election Board and other attendees, upon reviewing the official duties of the State Election Board, we noticed your responsibilities include investigating the administration of elections and frauds and to report findings to the Attorney General or responsible district attorneys, making recommendations to the General Assembly regarding elections, and developing rules and regulations about what constitutes a vote that will be counted. You have seen many such complaints since 2020 general election, yet the public and the State General Assembly has seen very few results from investigations or recommendations. On December 2020, Secretary of State Raffensperger ordered the Supervisor of Elections of Fulton County to reconcile their totals because, based on the count of physical ballots, Fulton County was 17,000 plus votes below the total reported on election night. This was not made public. What is clearly proven from the complaint is the recount did not confirm the report totals from election night. Votes were simply added to batches or discovered to make up the difference. Sometimes the same ballots appear to have been added in two places. With the additional 20,700 votes counted from unidentified tabulators that had already been added to the initial count, there is no paper documentation of ballots for nearly 42,000 votes. In all due respect, your decisions to act or not act can and are contributing to the destruction of the confidence of we the voters and the destruction of one of our most sacred rights, the right of a free and fair election.
Thank you,
This
Mr.
board
Carter.
has had this evidence for over 16 months. Reflect on the destruction of our rights and confidence in our friends since the 2020 general election conducted on an independent and since the general election, and please conduct an independent investigation of the Secretary of State of Georgia. If the President of the United States is not beyond investigation, the Secretary of State of the State of Georgia is not either. Thank you.
Linda Meek. Linda Meek. Linda Meek. I see one jazz hands, thank you. One faithful jazz hander, I appreciate that. Linda Meek, Linda Meek. Linda Meek.
First of all, Mr. Mashburn, I would like to sincerely thank you for a much improved prayer. Thank you. God bless you. By the way, is there a clock that shows us where our 2 minutes are up? I'm going to trust you to do it.
Mr. Cross was right dead on the money for 2 minutes. So
Okay, all right, here we go.
He's a good solid timer. He had it right on the money.
On November 17, 2021, Governor Kemp sent a letter to each state election board member concerning their Joe Wassie findings. He ended the letter stating, "It is a responsibility of the State Board of Elections to safeguard the confidence I and all of my fellow Georgians have in our elections. This is one issue where I believe this board must act swiftly, and I urge you to do so in this case. Members of this board have had vitally important issue information for 761 days. That's over 2 years. And now, according to the agenda, you're calling for another continuation. This has got to stop. You are all responsible professionals, and we are responsible voters in the state of Georgia. We, the citizens of Georgia, and I'm sure Governor Kemp, want the answers from the governor's original 3 requests. Direct investigators to review Mr. Rossi's findings, find as many as my office has, and order corrective actions as needed to address any verified issues and errors. Where is the corrective action? It hasn't occurred. He also asked whether any changes should be made to the risk limiting audit report. If so, the board should determine whether such changes adversely impact the integrity of the RLA report as originally reported. What changes have you made to the RLA? We haven't seen any. The third direction that he asked of you by the governor, review the audit methodology using counties across Georgia and create a prescriptive and uniform set of rules that ensure one process is followed by all counties that result in a clear presentation of data. Is there a draft report? Have you done it? We ask that you reflect on your professional careers as responsible professionals. How is this lack of action impacting the citizens of Georgia? Is this incompetence, a conspiracy, or a cover-up? In closing, let me remind you that the penalty for doing nothing is often greater than the penalty for doing something. And a continuation is doing nothing for the past 761 days. How long will you repeatedly do nothing? And I close.
Thank you for your comment. Kim Brooks.
My name is Kim Brooks, DeKalb County. Have you had enough about hearing about 2020 crimes yet? You're going to hear some more. I work with a team of data analysts across the state, and we've been analyzing Georgia Secretary of State files. We're doing things with those files he never thought we would do. We're finding fraud in every corner that we look. You've heard about several things today. I will add to that. Absentee ballots mailed to purposeful bad addresses, so there's return to sender. I don't believe we have New York City in Georgia. And it was mailed to New York City, Georgia, and Louisville, Georgia, and San Diego, Georgia, and Venice, Georgia, and you get the idea. We have manipulation of inactive voters that were turned active, voted, and put back inactive, which is impossible per our laws. If you vote, you get turned inactive. And my mic is off. We also have infrequent active voters that were activated, voted, and that looked proper until you look 2 more voter rolls, and they put back the date last voted from 2 months prior to the election. It is a cover-up of a crime. We have double voting via duplicate IDs, and yes, the gentleman that talked about all the cancellations in October, November, December, and January of 2020 to cover up the crime is mind-boggling. We are getting smarter. We're not going away. And there's more nerds in the group, and the nerds will save Georgia with the fraud we are finding. We expect this board to investigate the Secretary of State, but I'm going to leave you with the most important thing that we are uncovering in 2023, and that is synthetic identity theft via the Department of Driver Services. We have copies of the motor voter application that is fraudulent, with fraudulent signatures where they're stealing people's social, their birth date, it's inaccurate signatures. and it is a fraudulent government document sent to the election official to unknowingly commit fraud on the voter rolls in the United States of America. And that feed is coming via Jarvis. God bless America.
Thank you, Ms. Wright. Bill Hinders. Bill Hinders. Bill Hinders. Hey, Mr. Hinders. Welcome. Let me know when you're ready.
Thank you, Mr. Chairman.
The floor is yours. 2 minutes.
Okay. Our law says that in odd number years, the Secretary of State is supposed to do list maintenance on the voter roll. One law addresses active voters being moved to inactive status, and the other law addresses inactive voters being purged from the voter rolls. Per the Secretary of State's own files, he is far from following that law. Active voters should be made inactive if there is no contact in the last 5 years. Currently on the voter rolls, there are over 340,000 registrants that are inactive status with no contact in over 5 years. And what's even worse, one registrant literally has had no contact since 1972. 1972. Inactive voters should be purged if there's no contact after 2 election cycles. Currently, on the voter rolls, there are over 280,000 registrants that should have been purged this year, but weren't. We have one inactive registrant with no contact since 2000. Why isn't the Secretary of State doing his job and following the law? But it gets worse. Data analysts, which I am one of them, have found that in 2020, registrants that actually were purged in 2019 were suddenly brought back on the voter roll in October and November, get credit for voting, and then disappear again. This appears to be more election crimes and cover-up in 2020. The 2020 election should never have been certified. But I am concerned about the next election. If we don't fix these voter rolls and clean them up, we're going to have this same controversy, same legal and political drama over the next 4 years. We need to get it done. And the people demand an investigation into the Secretary of State's office. Thank you, Mr. Chairman.
Thank you, Mr. Henry. Next speaker is Nancy Curd. Nancy Curd. Nancy Curd, welcome.
That is me. Thank you.
Let me know when you're ready.
Okay, I'm ready.
All right, 2 minutes. The floor is yours.
Thank you. I was born and raised in my beautiful state of Georgia. Our law stipulates that the last day you can register to vote or change your registration address prior to an election. However, in the November 2020 election, being that the last day was October 5th, we had over 45,000 registrants after that day, between October 6th and 22nd, which was the date of the voter roll. Of those illegal applicants, we have over 5,000 that have a date last voted on November 3rd of 2020. They're unlawful votes. If you drill down and just look at the ones that registered on November 3rd, again, illegal, we have over 3,000 registrants that show a registration and a date added of November 3rd, and several hundred of them receive credit for voting. First, it's implausible to believe that election officials were adding thousands on the voter rolls on Election Day, and it's unlawful for any of them to have actually voted. I think we can agree on that. As you might imagine, the votes were cast in person on Election Day. Are these even real people? Or are they registrants just inserted into the count? It gets worse. We have over 1,300 registrants that registered after November 3rd, 2020. Again, I think we can agree that's not lawful, but they received credit for voting in the election. There are data analysts continuing this analysis and believe the numbers are much higher. This data is found across multiple counties in the state. These are all unlawful votes. Where did these registrants come from? Are they even real? We, the people, demand an investigation into the Secretary of State's office, and frankly, this isn't new information, basically, to any of y'all. You've heard this for 3 years. I'm stunned that this data doesn't at least tickle at least a spirit of inquiry from my state's Board of Electors.
Thank you, Ms. Kerr. Next speaker is Ginger Hermeyer. No, Ginger Herments. Sorry. We are number 22 of 30. And just to let you know, we're going to take a break at the end of public comment, so that we've been going for 3 hours without a break. So we're going to take a bathroom break at the end of public comment. It's limited to 30. We have 1 hour allocated, so it's going to be 30 speakers. Okay, the next speaker is Ginger Herments.
Yes, my name is Ginger Herments, and today I'd like to talk to you about DeKalb County ballots. Keep that in mind, DeKalb County ballots. Mr. Moncla sent another complaint to this board that has not been addressed or brought up for a hearing. He states in his findings, though an ongoing investigation and comparison of ballot images and data from the original November 3rd, 2020 count and those of the recount, significant irregularities have been identified, one of which is the discovery of 5 DeKalb County ballots, which were included in the counted Fulton County original count number 1, the hand count audit, and the machine recount. An impossible succession of multiple failures would have to precipitate a ballot from one Georgia county to be counted in a different county, much less 5 ballots for 5 different precincts at 3 separate counts. Mr. Moncla then goes on to detail out of the list of 6 election failures, including the ballot barcode scan, voter signature verification, the tabulator programming adjudication, hand count audit, and machine recount of 2020. He concludes this complaint with the statement, the implication of 5 ballots at issue is the complaint are indicative of a much larger problem than is of a grave concern. This is not someone asleep at the switch, but at every switch for 3 different counts. Furthermore, there is no way that the tabulators could have been able to read these ballots for either machine count, and there is no way that they could have been read accurately. There is no way the signatures from the voters from another county were verified, nor could those voters have received credit for voting. This begs the question, what voters were these ballots attributed to, and how? Is a corresponding voter even necessary? There is no suitable, theoretical, or even remotely plausible explanation for all systems, protocols, and procedures to have failed for each one of these ballots for all 3 separate counts. There is no excuse, but there is one conclusion. Georgia's election system has completely and astoundingly failed.
Thank you, Ms. Hermans. Thank you.
Thank you.
Next speaker is Maxwell Britton. Maxwell Britton.
Good morning, Maxwell Britton, Coweta County. And David Cross and Kevin Moncla were forced to resubmit their emergency review as a final effort before the 2022 election to urge you to address machine flaws identified and reject the unsupported comments of an anonymous state technician. In response to their original complaint, why would anyone be willing to accept an anonymous technician? Quote, several individuals in different capacities have witnessed the biased reversal of ballots. Independent benchmark testing recreated the scenario under controlled conditions and yielded the same overwhelming biased result. Republican voted ballots were reversed at a ratio of 7-to-1 over Democrat voted ballot reversals. Because the distribution of ballot reversals is not random, suggests intentional influences at play. In essence, ballots are being reversed for error conditions that do not exist. This testing and testimony show that the ballot reversals are not random. Significant numbers of paper ballots were scanned but not counted, and consistent with the Williamson anomaly, and remain otherwise unexplained. For whatever reason, your state technical consultant mischaracterized their presentation. We believe that the documents and reports provided are sufficient to establish that Georgia scanners are malfunctioning en masse if analyzed by an independent examiner. No matter if caused by defect, malware, or malfeasance, the results remain and persist. This alone is sufficient to cause immediately, this is sufficient to cause and immediately suspend the use of Dominion voting systems in Georgia. Once again, the voters in Georgia are silenced by an anonymous technician or an anonymous report. Where is the leadership demanding transparency and the use of experts? Isn't this your job? This report has the evidence, and once again, you ignore it. Thank you.
Thank you. Thank you, Mr. Britton. The next speaker is Nancy Arnold. Nancy Arnold. Nancy Arnold, welcome.
Thank you. Thank you. I'm Nancy Arnold. I'm a DeKalb County resident. Several weeks ago, a member of the State Board of Elections, Dr. Janice Johnston, attended a DeKalb County Elections Board meeting addressing challenges to the voter rolls. At the end of the meeting, Dr. Johnston commented on the frustrations surrounding the process and promised that the state board would come up with new guidelines for the process of challenges, guidelines to clarify and improve the process. Thank you, Dr. Johnston, for your willingness to help and for your time and attention to this important matter. I've sent 2 emails since that DeKalb meeting to the members of the state board asking about when the guidelines would be available. I received no response. Can you give us an update today on the status of those new guidelines? Thank you.
Thank you for your comments. The next commenter is Paul Hershey. Paul Hershey. Welcome. Let me know when you're ready.
I think I'm ready now. My name is Paul Hershey. I'm in Fulton County, and I'd like to be very direct and pointed. Number one, the audit that the Secretary of State said took place in 6 counties, there's emails validating that it never took place.
If you could step just a little bit away from the mic, you're coming in really loud.
How about now?
Much better. Thank you.
Okay, good.
Thank you so much.
The other thing is our protocol inside our voting inside the state of Georgia violates HB 316, line 536 and 535, because the elector cannot verify 100% who they're voting for. Number 2, we're also in violation of U.S. Code 450, Section 452-97, because by the time they mark their ballots, they go over to the scanner, every Tom, Dick, and Harry can see who they voted for. You guys are mandated, and you've taken an oath to support and defend the Constitution, both federal and state. You, a Board of Education, are mandated that you can go to the state IG, the Inspector General for the state of Georgia, ask for an independent audit of the Secretary of State, and you haven't done it. Why? My question is, why? When are you going to do what you need to do and to support the constituents of your state? You are responsible for the elections of the state of Georgia. You've got the authority to do those things, and you're not doing it. What are you doing? That's it.
Thank you, Mr. Hershey. The next speaker is Victoria Cruz. Victoria Cruz. Welcome.
Victoria Cruz from Athens, Georgia,
You're good to go.
in Oconee County.
The floor is yours.
Thank you. Let's see. The facts of the Joseph Rossi and Jack James complaint, SEB 2021-181, and its resolution by consent order with Fulton County in 2022 are well known to you. And because of the extensive social media coverage of that case, they are also now known to large numbers of American citizens. Another Rossi complaint, the 2023-25, has again been continued, presumably because its allegations have serious implications about the validity of the 2020 presidential election outcome, which the board appears loath to explore. All eyes are on Georgia and on Fulton County for good reason. Fulton County was not the only county with voter and election anomalies in 2020, but it is the county with the most egregious errors that by themselves, if proven, could reverse the results of the 2020 presidential election. And yet the Secretary of State, his legal and investigative staff, and the Attorney General's office have failed to conduct honest and transparent investigations of complaints. In fact, the response of both offices in many cases has been to attack the complainants, some of whom have lost their jobs as election workers or election directors. Are these appropriate actions for those who claim that the 2020 Georgia election was the safest and most secure in the history of the state? The citizens of Georgia are essentially being held hostage by these offices and are depending now on the state election board to uphold its responsibilities and perform its duties, which are listed in the code. I urge the board to initiate an independent investigation of the Secretary of State's office, because they've proven that they are not motivated to and or capable of investigating themselves.
Thank you, Ms. Cruz. Next speaker is Dan Gazaway. Dan Gazaway.
Thank you, Mr. Chairman. Am I
Welcome.
too far or too close?
You're right on the money.
All
Mr.
right.
Gazaway. Thank you.
I'm back this month on State Election Board case 2018-104. Last month, I was with my friend Catherine Engelbrecht out of True the Vote up in the federal courthouse in Gainesville on a case, and she brought it to my attention that y'all had sued her for evidence. So I brought some certified evidence of felony criminal activity just in case, so y'all don't have to sue me for evidence. I will give you as many felonies as you can find somebody to prosecute. But I was with Ms. Engelbrecht because I am the person who challenged the lone real plaintiff in that case, and that was about election challenges as well. But I'd ask y'all today, do two things. If we could dispose of 2018-104 and move it to the Attorney General's office, that would be helpful. I asked for an FBI referral. That's not going to happen, it don't look like. But if you would go ahead and do it, it looks like I'm going to have to fund and bring the quo warranto of all quo warrantos in the history of Georgia. And I'd like for that case to be disposed of before I brought that quo warranto. But I'd also like for you to consider, withdrawing the suit against Ms. Engelbrecht's group. They've done good work in Georgia. I think the federal case made it clear that the person I challenged was an illegal voter. We put it on the stand. There's really no way around it. In fact, of the 50 I challenged, really, I think all 50 were illegal voters. 44 have now confessed to being illegal voters. The other 6 won't admit it, but two things. Consider withdrawing the case against True the Vote, because otherwise, let's prosecute all the felonies. And I'd like to leave this certified evidence with your lawyer if you can tell me who that is. Oh, which one? Raise your hand. Okay, and please dispose of 2018-104, because if I've got to fund this protracted litigation with these big lawyers again and spend all this money that I've spent, and y'all know my record, I am the only person in the history of this state to throw out the same election twice. And nobody, I wish I had a crowd like this donate to me back then. I wouldn't be down $138,000, but I am. So I want to see some change. I'm going to fund this quo warranto if I have to. And we're going to take out the illegal sheriff. See, they don't even know we're the only state in America with an illegal, unconstitutional sheriff roaming our state, and he's the president of the Sheriff's Association. You can't make it up. Thank you for your service to the citizens of Georgia.
Thank you, Mr. Gazaway. Thank you, Mr. Gazaway. I'll also take that from you.
Brenda Heidman of Columbia County. I believe it's Heidman. Correct me if I'm wrong, please.
Hello.
Did I get it right?
Yes,
Heidman?
you did.
Heidman?
Yes, you did.
Very
Heidman.
good.
Yes.
Brenda Heidman, the floor is yours.
Thank you. Thank you, State Election Board. Can you hear me? Okay, I can't hear myself.
Your mic is on.
Can you hear me now?
Pull it a little closer.
A little closer?
Yeah.
Okay.
Very good. All right.
Thank you.
I think we can hear you.
I'm here for paper ballots and to remove voting machines and to speak on the inaction of the Georgia state leaders, the elected leaders, the legislators, and the state election board as well. The inaction hurts voters and citizens of Georgia. The inaction hurts the future of our children, grandchildren, great-grandchildren who aren't born yet, because they will see how wrong the voting machine process is and how paper ballots were not instituted. And they will come back and ask why. 5, 10, 15, 20 years from now, we won't be here, but we'll be leaving our children, grandchildren, great-grandchildren to inherit a big mess that will be harder to fix. So, paper ballots, to me, it's extremely simple. It hurts no one. It's for everyone, regardless of political party, regardless of income level, socioeconomic status, education, regardless of race, religion. Paper ballots is for everyone and hurts no one. To me, it's a simple solution. Please, I ask you, please, to push for the paper ballots, to remove the voting machines and make the state legislators and the state leaders do what they're supposed to be doing.
Thank you, Ms. Heidman. Thank you. Thank you for your comments.
Okay, thank you.
Our penultimate speaker is Chairwoman Grubbs. Chairwoman Grubbs? She had to leave? Okay, so Diana Hopper. Diana Hopper. Diana Hopper. Two minutes, the floor. Let me know when you're ready. Take your time.
I'm not.
Take your time. Okay, 2 minutes. The floor is yours.
From Floyd County here, speaking on behalf of myself, Mr. Graham Grimes, and two of his poll workers, Sharon Seckinger and Joy Battles. Mr. Grimes, he's a 10 years plus poll manager and a poll worker prior to those years. Sharon has been a poll worker since the 2016 election. Mr. Grimes takes great pride in being very meticulous and organized running his precincts. Yet, he thought he was not going to be needed because he had not been contacted. Yet, 1 week prior to the election, our election supervisor, Aiken Beck, called him. He was very upset, but he went ahead because he loves our country, in our county, and went ahead, and it sent him into scrambling to contact his poll workers and to get himself organized. At a special meeting, Board of Elections meeting on Monday, November 13th, he was there speaking, as myself and others, and the two poll workers, as I mentioned, and they were very, very upset. They had this, I have the original of what I handed to you. There were more than 100 voters that were disenfranchised. As you see at the top, it says there were 10 more before they even started this list. They started to get a barrage of people coming in. And that's just from 2 poll workers. The other 2 poll workers, I was not able to contact them, but they also had lists. Of those that came in, that many of them, most of them, it was their second time being directed to the new precinct. And then there were others that it was their 4th time. They were upset, threw their arms up, said, I'm sick and tired, I'm not going to go to one other precinct. They had been disenfranchised, they were angry, they were mad. Yet, this election was certified. How can that be? Ms. Virginia Harmon, our county attorney at a caucus of the county commissioners, said that the election went well and voter cards are not required to be mailed out. How are the voters supposed to know their new precinct if they don't receive voter cards? Myself, many others that were there at that meeting, we expressed our upsetness. We were very upset that I still, to this day, have not gotten my voter card for the new precinct I'm supposed to attend to vote. If I had not gone to those meetings, I would not have known. I would have been just as those going from precinct to precinct. Yet there was I have a picture here of some signs showing of where to go. It says if you have voted here to go to the new location, and then this is the building where where we have our election meetings, Board of Election meetings, and yet it didn't say come in here and find out where are you to go. A lot of people just saw this and they left.
Thank you, Ms. Hopper.
Just one more really quick.
Okay.
So these precincts were consolidated because from 24 down to 19, but why? And whose idea was this? They claimed that it was to save money. Why not get rid of the outdated, expensive, compromised machines and go to the paper ballots?
Thank you, Ms. Hopper. Thank you, Ms. Hopper.
This election should not have been served.
Thank you, Ms. Hopper. Thank you, Ms. Hopper. That concludes the public comment section of the agenda. And just for planning purposes, we're going to take a restroom break for about 10 to 15 minutes. We've been going solid since 8:30, so I know that'll be appreciated. And then we will come back and do old business and new business items, agenda item number 5. Then we'll break for lunch, and we'll come back and do investigations reports after lunch. So that's the schedule. I don't understand the question.